Just before we begin formally, can you just confirm you can hear me?
Confirm, sir. Can hear and see you fine.
Good.
Yes.
Okay, I'm going to start off with the advocates, Mr. Taylor, when I open, so you can perhaps hide your screen for the for a period while we just go through a few preliminaries with the barristers.
That okay?
Yes, thank you very much. Yes. I'm waiting for Mr. Atkinson. So we'll wait until he appears, and then I will commence proceedings
Yes,
formally.
sir.
If I could ask Miss Ellis, is Mr. Atkinson due to be joining us?
Yes, he is due to be joining us. I've just sent him a message to see where he is, but he is supposed to be in attendance.
Okay, right. I see there's live streaming available. Is that going to commence? Has that commenced now, or does that commence when we start formally?
I think that's already started now.
Fair enough. Well, it is slightly past 9:30 now, but I will treat this as an adjournment and not start until Mr. Atkinson appears, because clearly we need his presence.
Yes, agreed, sir. Happy to hang on for.
Yes, just
if it turns out for whatever reason that he'll be more further longer delayed, then we can have a proper adjournment. But if he's sort of imminent, then we're probably
yes. Okay, I'll wait and see if I can get any news from Miss Ellis. And I assume Mr. Maxwell is on standby to talk through the conditions. Would that be a correct supposition?
It should be. Oh, I think I missed it. I think it might be D. Is it DM, David? Is that you? Let's see. Yes.
Good morning. Yes, that's correct. Yes,
I'm relief. What a relief.
Because I didn't do a formal agenda for this, but going by the program, we are dealing with conditions first.
Fine. Either way, answer whatever.
That will take a little while. And then the 106, where possibly we'll be having a lawyer from the council joining us.
Yes, indeed. So
we've also all agreed, so that needn't be a lengthy.
We've also got a solicitor from our side as well. So just so Miss Lilliot too is on the line. Let's check.
Yeah. Yes, I'm here.
Okay, thank you. Glad you're here.
It's agreed. The drafting's agreed, but there will be a few items that we want to just get cast your attention onto, with an eye on things like Reg 122 and necessity and all of that. But the drafting is all agreed.
Excellent. Good. And when we do formally start, I got the conditions quite late. In fact, 10 minutes ago. So I would be very grateful if Miss Ellis and Mr. Maxwell could talk us through those.
Yeah.
And also, I know Mr. Taylor
Giles,
has got...
sorry, Giles is just joining us.
Oh, excellent, excellent.
Yeah, it's fine. We've sorted it out. He's just messaged us. It's fine. Okay, thanks. Fine.
Good morning, Mr. Atkinson.
I'm so sorry, sir. I'm so sorry. I thought it was 10.
That's okay. I will now formally open this session of the inquiry. It is being live streamed, so those interested parties, and I know there's a lot of concern over this proposal, can hear proceedings, so everything's in the open. So I think if we could just have the advocates' cameras on first of all, and I'll just run through how we're going to deal with matters today. Item 1 will be a discussion of the conditions, which I will ask Miss Ellis to lead on and Mr. Maxwell to comment. And if Mr. Taylor has any particular points relating to conditions, or indeed anyone else participating, if they could do the thumb raised facility on Zoom, and so I'm aware that they wish to interject. But so that's what we will be dealing with first. We will then, depending on time, have a break at an appropriate time, but probably run through and talk about the Section 106 agreement. Once we've dealt with the conditions in the Section 106 agreement, we will hear from Councillor Schrader, who unfortunately was poorly last week, so didn't make the inquiry, but I have granted him an opportunity to make a statement, which parties have agreed to, which will, I think, provide an opportunity to summarise the concerns from interested parties, which I think is all well and good and fair. I will then hear Mr. Atkinson's closing statement, and then finally, as is customary, the closing statement from the appellant. The elephant in the room, if you like, is the fact that we are possibly going to get a revised National Planning Policy Framework published today. Ourselves in pins of, well, I've had no prior heads up from government when that's likely to be, so I'm just going on blogs and newspapers and so forth, but it looks like it could be announced this morning with a speech from Michael Gove. That's my knowledge. So we will take a rain check. I'll take a rain check with the barristers on that, but clearly that will have implications on the need to reconsult and possibly hear closings at a later time based on what the framework says. I don't know if Mr. Atkinson, Mr. Simons.
I'm just going to make a suggestion. Obviously, we've known this was. We didn't know exactly what day, but it is going to be today, as you say, sir.
Yeah.
My suggested course would be, when this sort of things happened before, would be that we close the case today, but we allow further written representations from the local authority, targeted only at the implications of changes to national policy, because we can't have it obviously become a general sort of,
yeah, I hear what you're saying. Yeah,
it would have to be targeted reps on specifically, which paragraphs or whatever it might be in the changes have implications, what those implications are. That's submitted to you in writing and a time frame to be agreed. And then we do the same. We have the final written response on whatever those changes are. And that's how we deal with it. I think that's obviously you will, in the end, it's not a brand new framework. There'll be changes to paragraphs that are already there, sort of thing. So we don't need to sort of, reopen the inquiry and hear lots of new evidence. But we do need, obviously, an opportunity for the council and then finally for us to address you on whatever the implications may be of those changes. So that's how I'd suggest doing it.
That's your take. That's fine. Mr. Atkinson, do you have any...
No, I agree with that. It makes sense. rather than postpone closing entirely, which I think was what you were possibly hinting at.
No, hearing from you, so we will hear closings, but it looks likely that we'll get a framework published around 11. It may not happen. I don't know. I've got no more knowledge than you have. But once, assuming it is published, and I think it's quite likely, I will receive advice internally from PINS as to how to proceed. And clearly then we will almost certainly be reconsulting on the changes to the MPPF, both to the council, the appellant, and indeed interested parties, and taking those further comments into consideration.
Yeah.
So, having said that, let's crack on with the conditions, unless anyone's got anything else to say.
So thank you.
Excellent. Okay. In that case, if I could invite Miss Ellis and Mr. Maxwell to have their cameras on, and well, I don't mind if the barristers keep their cameras on, but it depends on who's likely to be participating most actively in this. One thing I am slightly concerned about is that Mr. Taylor probably may not have had a copy of the conditions.
No, the copy of conditions hasn't been forwarded to Mr. Taylor. I can send them to him now if you wish.
Not the full.
Okay, well, we will take the conditions at a sensible pace, but I think a lot of them will be fairly routine technical conditions, which I'm not inviting a huge amount of debate on. I know that Mr. Taylor is particularly concerned about the constructional effects should permission be granted, and where workers park their cars and that kind of thing. So when we get onto that particular condition, it's likely that we will hear what Mr. Taylor has to say. So without further ado, and you are sending Mr. Taylor a copy of the conditions, is that what?
Yeah, that's fine, no problem. Christine did just inform me that she did send Mr. Taylor a copy of the Kennel Lane conditions, which is what these conditions are based on. So,
okay.
But I will send Mr. Taylor a copy now to him.
That's very helpful of you. Thank you.
Yes, I can confirm that I received such conditions as hard copy, but I'm concerned with enhancements to such conditions.
Okay, well, let's see how we get on then. And so I will invite, so I've got them in front of me and I haven't read through them even, but I'm very familiar with planning conditions, so I don't think it's going to be extremely onerous for me. But I would invite Miss Ellis. Some of them you can deal with very quickly, like the standard ones, but it's over to you really. Talk us through it. And Mr. Maxwell, you come in when you need to, if you could. And obviously we need to have particular discussion on any points of disagreement and any concerns that Mr. Taylor has. So over to Miss Ellis, please.
Thank you. Okay, so 24 conditions have been recommended all together. So we've got the scheduled conditions, so it's the standard reserve matters to be submitted conditions. And then we've got the timing of reserve matters submission. And then we have timing of reserve matters commencement. And then we have an approved plan and document condition as well. We've also got a condition that relates to the reserve matters application, saying that there should be no more than 150 dwellings and there should be a care home on the site. We've also restricted the use of the care home to C2 only.
So can I just pause there? I don't think there's any particular contention with any of those.
No.
No. Okay.
Shall I go?
Sorry.
Shall I go to the one?
Yeah, I was just sort of finding a natural pause, so apologies for interrupting your flow.
So there was no contention with condition 7 through to 17.
That's correct, yes.
Yeah, the only one with 17, which I did email this morning about, David, was
I'm sorry, I missed that. Condition 7 is
17.
relating to a design code.
Oh yeah, so the design code that we requested on condition 7. But we've not raised any contention with any of the conditions from 7 to 17.
No.
They would be okay. So condition 17, David, you've asked for a deletion of bullet point 5, which relates to the detail of any offset provision to be secured by planning obligation. And we're happy.
No, just for clarity, I'm proposing that bullet point should remain, not be deleted.
Right, okay, that's fine. Okay, that's fine. I'm
not 100% clear on what you're telling me, really. Bear in mind, I've not read these conditions yet because they came very late in the day.
If I may just say that the appellant agrees on the draft wording of conditions 1 through to 16.
Yeah.
And then
condition. Then when we get to 17, we'll have a bit more of a discussion.
That's correct. Thank you.
Okay, thank you, Mr. Maxwell. Okay, over to you, Miss Ellis. So just can tell me a little bit, very briefly, about what condition 7 is. It's about design.
So just condition 7 relates to the requirement of design code to be submitted for well, each phase, depending on how many phases you put forward. But yeah, we just require design codes, so sort of details of materials to be used, details of the public realm, characters of each part of the site.
Okay, so I think that's all well and good. It's in the interest of good design, so I don't think there can be any quibble on that. I think the next condition, number 8, is possibly one we need to
yes, the prior
involve Mr. Taylor on. So if you could explain that.
So the prior commencement conditions that start from 8 to so the number 8 relates to construction environment management plan, which relates to site waste management and the construction of logistics. So I think this was one that Mr. Taylor did raise concerns with, or wanted things to be added into. I think it was this one. So this just relates to the environment management of the site, and there are requirements set out between A and L, which was required of the developer to put details forward. And I think, like I said, I think this one that you had concerns with, Mr. Taylor, or wanted to add certain things into, the parking of vehicles and construction vehicles.
Yes, well, I'm ready to speak if that's correct, Chairman.
Yes, just explain what you'd like a construction environmental management plan to include. Now, this does include things like the parking of vehicles for site operatives and visitors. So I think it would cover the prevention of parking on Potash Road or anywhere.
Well, okay. The wording, I've opened up the form of the question and now reads, with about 120 construction workers at the site over 3 years, how do you propose to minimise road traffic and avoid on-street parking? That's my first.
Right. Well, I think, Miss Ellis, if you could explain how that condition might address that.
So the condition here, condition 8 to L, requires a developer to satisfy that criteria that's set out. Obviously, I know you've got concerns about the amount of workers that are going to be on the site over a period of 3 years and where they're going to park, but we will require the parking of vehicles site operations to be indicated on a plan to us that we can look at and discharge. Obviously, we prevent any sort of parking on Potash Road, and we'd want parking to be within the actual development site itself.
Well, am I allowed to ask whether that specifically means provision made on site or at a second site, or
it'll be on site?
Right. So I'm sorry, but I can't see that addresses minimising road traffic. 120 cars and vans coming in every day and going out every day is a lot of additional traffic. That's my observation.
I think the condition, as I see it, includes a signage and routing strategy I think at the end of the day, construction involves a certain amount of upheaval. The quicker it's done, the shorter that upheaval will be. But I think it's a condition that is inclusive of certain requirements, but I think it can include other things. Am I correct in?
Well, I did venture to suggest that the developer could provide a parking site some distance away to take the 120 vehicles and the personnel and the tools to transfer to a shuttle bus or series of shuttle buses, generating far less traffic entering and leaving the site.
Any comments on that, Mr. Maxwell, from your... I'm just thinking possibly contractors will be coming at different times, doing different things. How practical do you find that to be?
I think that may be quite difficult. I think the condition as drafted and proposed is standard and would be quite appropriate in this particular instance.
Okay.
Okay. Can we register disagreement? Okay. Moving on to the truck traffic. The materials and waste. My question now reads, with 10 or more truck trips to and from the site each day, how do you propose to minimize truck traffic in peak hours? These are large, unwieldy vehicles, and they've got to navigate the notorious Junction 2 Stock Road, Potash Road roundabout. And to be hardly welcome because at peak hours, as we heard, the predominant flows are north-south, and these crossing flows are therefore impediments.
And perhaps Mr. Maxwell can help us on that, whether the condition provides any assistance in that.
Well, I think overall this condition requires full details of vehicular movements to and from the site, and it will be for the council to agree those requirements and those conditions. Again, I'm struggling to see a necessity or requirement to go beyond the standard requirements set out in this condition.
Well, I did my best to make an estimate in the absence of such specific information as to the number of bricks in 150 houses and a 3-story care home, and then the raft of other materials, which I won't attempt to specify, but I judged that bricks alone would account for only about 5% of the total amount of material to be moved. And so I believe this needs assessment, and we need, I suggest, a specific prohibition from parking in Potash Road, which is narrow at the best of times, and the trucks would block off legitimate access, householders, and parking partly on the road and partly off on the footpaths would very swiftly destroy the footpaths. And I believe it should be suggested that reparation be due immediately to remove the hazard to pedestrians from any such damage.
I think from my reading of this condition, it will require agreement to measures that would address those concerns. I don't think it could supplant any requirement for traffic regulation orders, so I don't think it can prevent the legitimate use of the highway that's unrestricted otherwise. Could the planners help me on that one with any comments they have? Perhaps Miss Ellis?
Yeah, I was just reading through the condition. So I have highlighted a couple of bits for you, Mr. Taylor, that will hope assist with your concerns that you've got. So as part of the condition, a construction traffic management plan is to be submitted by the developers. Also the parking of vehicles. So generally within large developments, there is a compound that's generally outlined where visitor parking, so anybody employed to work on the site park, storage of materials that'll be there, and also offices set up for general managers that will visit the site. So the parking will not be on Potash Road as you fear. And also there is a highway condition survey that has to be submitted as part of this condition, as well as a construction phasing plan. So obviously the site may not be built out all at the same time, so it'll be phased, which will then alleviate any impact on the surrounding neighbouring properties if the development is phased out and built in different phases. So that should address any concerns that you have. Obviously the developer has to be mindful of peak times travelling, and as the inspector would said, there will be sort of a routing plan as well, that direct construction traffic towards the site. So hopefully that this condition, it is standard, it should address the concerns that you have.
One particular point on the routing, I wonder if you care to address the issue of the blind bend in the other direction, because I suggest that two trucks could not pass each other. So if one were coming to the site and the other leaving the site, then that would, anybody local had seen the wing mirrors, etc., debris at that point, and one of the other residents who spoke on the first day, she's got photographs of vehicles mounting the pavement, the single pavement, in order to pass each other at this. So I wonder, should we require that no truck traffic pass this way?
Mr. Maxwell, I imagine a routing strategy would be one way of encouraging traffic to come in.
Thank you. Yes. So criteria K requires details of the signage and the routing strategy. So again, there's potential or scope there for the authority to control the routing of construction vehicles to and from the site.
I think a lot of the concerns that Mr. Taylor has raised are actually addressed in this condition. It can't overcome highway rights generally, but I think it would be a means of encouraging or making sure that contractors comply with certain restrictions. I think it might fall short of requiring shuttle buses and things like that, because contractors will be coming in at different times and that may not be practical. But I think to a large measure, this construction environmental management plan does touch on a lot of the concerns you've raised. So any final points you need to make? The next condition covers biodiversity, which is another, I think probably another concern of yours during construction.
That's correct, Chairman. Yes. So under ecology,
I'll tell you what, before you come in, I'll invite. I think we've explored the construction environmental management plan condition. If we now can move on, Miss Ellis, to the next one, which is a construction environmental management plan.
Yeah. So this is for, like you say, construction environment management plan that relates to biodiversity. There are in bullet points under that condition 9, there are criteria that need to be met by the developer again. So we need sort of protection zones that are outlined, so for badgers, etc. We need sort of location and timing of when the work's going to take place, and times during the construction that we need an ecologist on site to oversee the works that are taking place. and obviously protected fences that should be within the site. Your concerns with that, Taylor?
So,
yes,
Mr. Taylor.
thank you, Chairman. Yes. So it's phrased, with all the construction workers and noise over 3 years, how do you propose to avoid driving away wildlife, especially dormice, so that, by so addressing, the site could be licensed by Natural England?
Well, I think the answer lies partly in this condition. Perhaps Mr. Maxwell can say a bit more about how this condition might be applied to.
Yes, so this condition again is quite standard and seeks to and will protect biodiversity on the site throughout the construction phase, and importantly, an ecological clerk of works will be responsible and have a role to ensure that that is the case. So they will be overseeing and ensuring that all steps, all activities throughout the construction phase protect biodiversity.
Well, Chairman, I have difficulty in accepting such reassurance. If the dormice all vanish, I can't see any mitigation short of forced reintroduction that could ameliorate the situation. And as we've heard earlier in this inquiry, well, for the loss of the dormice, the scheme was lost.
All right, so I hear what you say. We've discussed ecology and particularly dormice during the inquiry session. I think my view would be, as with the effects of traffic and so forth, construction is not without impacts, and no doubt this will have some bearing on wildlife. Quite clearly, there's going to be houses built were the appeal to be allowed. Again, this is all without prejudice, this discussion of conditions, but the condition does set out a number of mitigatory measures, including an ecological clerk of works, which at least addresses the concerns you've raised.
Well, I understood that licensing by Natural England was, to put it crudely, a job stopper. If that could not be achieved, then the scheme should not go ahead. Am I right?
There's the wider issue of whether it's likely that a license would be granted, and that will form part of my considerations over the general impacts of this proposal on dormice and biodiversity. Should I be mindful to allow the appeal, and I'm not anywhere near making a decision yet, I would need, this condition would be one means of reducing or mitigating any residual harm. So it would be, obviously, I'm aware that you would prefer the development not to be permitted. Well, that's very clear. But if it were to be permitted, this condition seeks to minimize, if you like, the negative effects.
With respect, is not the presence or absence of dormice what they call a binary condition? In other words, it's not capable of mitigation.
Has got is coming in to help me on that particular question.
Sorry, I was trying to figure out how to put my hand up on this thing. Mr. Taylor, I mean, the condition does relate to obviously a protection zone. So once, and also if you skipping forward, condition 16, there is a requirement in there for the ecological impact assessment where we are asking for further ecological surveys to be carried out for this site as works progress on it, should the inspector be minded to approve. So that should hopefully satisfy the concern that you have with regards to the ecology that we've established that are on site, the badgers, dormice, etc. And also there are, I mean, the other criteria in this SEMP biodiversity condition to sort of ask for practical measures to avoid and reduce impact during construction phase, stuff like that. So together with condition, what is condition 8? Is it 8? The biodiversity one together with 16 should hopefully satisfy 9 and 16. Sorry, should satisfy your concerns that you do have with regards to the dormice and other ecology species.
Well, in a sense, of course, it's not my concern, it's Natural England's concern. But I'd like to add a second on this point. After construction, how do you propose to avoid disturbance to wildlife due to artificial light and predation by domestic cats?
Well, I think you're reopening what was discussed at the inquiry, but
Okay.
there are further conditions which relating to ecology, which Miss Ellis has touched upon, which I think might, might help us a bit on that particular concern. But I think the issue of biodiversity and dormice has been discussed. It's a primary main issue.
Yes.
We're dealing with the hypothetical situation of approval and then conditions that then address the residual concerns, which so I'll invite Miss Ellis to carry on, because I think some of these conditions are less contentious, and then we could perhaps pause on the more significant ones. So over to you, Miss Ellis.
So condition 10 relates to land contamination site investigation, with 11 and 12, which both relate to land contamination. These are standard investigated conditions that are generally recommended for this type of development. 13 relates to archaeology investigations. So again, this is standard conditions that have been recommended by Essex County Council in terms of investigating sort of the site prior to sort of development taking place. Then we move on to condition 14, which relates to surface water drainage scheme and flood risk. Again, it's a standard condition that's been recommended by Essex County Council, and to ensure that the site or the scheme doesn't prevent and doesn't cause flooding on the site. Condition 15.
Just to stop there, because surface water drainage was an issue. Condition 14 requires details of surface water drainage to be fully ironed out and implemented, just so that everyone's clear.
Yes.
Sorry to interrupt you. And 15, I think, is a long condition, so there's a lot of.
So 15 relates to surface water drainage scheme and flood risk. So we do expect a scheme to be put forward to us by the developer to sort of minimise the risk of off-site flooding caused by surface water on the site. 16 relates to the ecological impact assessment, which we've addressed previously regarding.
Now this links on to what the general concerns, that if permission is granted, what does this condition do? Just summarise.
Ecological surveys to be carried out by the developer prior to the development commencing, and this just kind of assures us that there is an updated, so we know what is on the site at that current time prior to commencement.
So there's further ecological surveys before the spades are put in the ground, so to speak. So that's a further
at that current time.
So further addresses any. We know there's concerns over biodiversity, but were permission to be granted, this condition requires the species a survey of what's there just before construction takes place, and then means of securing, minimising harm.
Yeah, exactly. Securing any mitigation measures that are put forward.
Do you have any questions on that, Mr. Taylor?
No, Chairman, but there's one I did not hear addressed, and it reads: how do you propose to avoid noise emission from the site outside business hours. I'm thinking of the effect on neighbouring residents.
Yeah, again, I think that's probably, that will go back to the construction and environmental management plan would provide unless there's a condition specifically limiting hours, that's sometimes included outside as a separate condition. Bear in mind, these conditions, I'm looking at them for the first time as well.
I see. But we are talking about a duration of 3 years. This could be,
Sure.
let's put it, damaging to mental health.
There would, Miss Ellis.
Sorry. Condition 8, criteria G relates to measures to control the emission of noise, dust and dirt during construction. So, sorry. Oh yeah, there's hours of construction as well.
That's the very point. It's the combination. Yes.
Yeah.
So there is the two issues of addressing noise generally and addressing the hours of construction hours
Disturbance.
are covered in the condition.
That's right. Thank you.
Thank you.
17, thank you. So condition 17, this relates to the biodiversity net gain. And this is where Mr. Maxwell has added in a bullet point to say details of any off-site provision to be secured by a planning obligation. So this net gain plan should include from the developer sort of baseline data collection of currently the site, a commitment to measures in line with mitigation. I think we've asked for 10%. So 10%, minimum 10% measures here to be put forward to us. And as I said, you have added a bullet point, Mr. Maxwell, about the details of any off-site provision to be secured by a planning obligation, which we're happy to accept.
So this condition require, because this is an outline application, full details of biodiversity net gain, which is a forthcoming statutory requirement on development, but isn't applying statutorily to this proposal because it came in earlier. This condition ensures the delivery of the biodiversity net gain calculated by the appellants, which I think was 17%, Mr. Maxwell, which is somewhat over the...
Yes, that's correct. The calculation, it was 17% to be secured in parts off site. This condition is very much mirroring the wording that Essex County Council themselves have provided for a BNG condition, and the county recommendation includes that the additional point of off-site provision to be secured through the BNG by a planning obligation.
So that covers biodiversity net gain, shortly to be a statutory requirement for all development, but being delivered hypothetically through this condition. Could you carry on then with 18, Miss Ellis?
So condition 18 relates to measures to protect badgers from being trapped during the construction phase of the development. Again, that's generally standard. Then we move on to the details to accompany reserved matters submission. So condition 19 sets out criteria between A and O. I'll point out for Mr. Taylor's purpose, criteria J does relate to external lighting strategy. Obviously, we are mindful that there are dormice, etc. on site, so an adequate lighting strategy should be put forward by the developer to assist with that. And also, there is a landscape and ecology management plan as well that needs to be submitted to us that we would consider at that time. But yeah. This requirement does ask for sort of the tree survey to be submitted, daylight and sunlight assessment, sort of updated biodiversity surveys and biodiversity compensation enhancement strategy to be submitted. There's other things that have been asked for, such as external finishes of the site levels. We were asking for full details of internal layout of the dwellings themselves, as well as sort of maintenance plan of the surface water drainage system. and refuse and recycling. So there's quite a lot in there that we're asking for, but we do feel this standard, and it has been recommended and imposed on other outline applications that we've recently had granted.
Mr. Taylor, do you want to?
Yes, thank you, Chairman. I heard about the nature of the dormice settlements, and I understood that one of the features was continuous viable habitats, in that they typically migrate, move, perhaps even seasonally, but so I'm concerned about off-site provision, which is all well and good, but if we've, as it were, ruptured the migration pathway, then this is seriously detrimental.
Right. I think in a sense you are revisiting the sort of general main issue concerns. We're dealing here with a condition which require, bear in mind this is an outline application, so the actual details of the landscaping and where the houses go isn't fixed. So there is, you know, the provision through reserve matters to consider, you know, linear connections for dormice and that kind of thing. But it sets up, this condition sets out a number of specific requirements regarding lighting, tree surveys, arboricultural method statements, various things that are seeking to ensure that should outline planning permission be granted, then the subsequent reserve matter applications address various things like trees and so forth that Miss Ellis has explained. Mr. Simons, you've
yes. So just to say that I must say I've got a few concerns about this condition. I mean, ultimately, if you impose it as is, we live with it and that's fine. But I think we've got to remind ourselves about the tests that we've not spoken about too much so far, because the main parties are agreed on all of the conditions.
Yes, sure.
I mean, the conditions have got to be necessary. They've got to be justified. They've got to be proportionate. We've got to remind ourselves that by their very nature, the reserve matters submission, if and when it's made, is going to cover the details of appearance, aspects of a building, reading from the PPG, which its external built form, its architecture, its materials, all of that stuff. That's covered. It's landscaping treatments, which means it's screening, planting of hedges, trees, all of that stuff. It's layout and it's indeed its scale. All of those terms, of course, as you know, defined in legislation, defined in the planning practice guidance. Several of these simply duplicate what we'd have to do anyway, and to that extent are unnecessary. Other ones of them go further than what we'd have to do anyway, but in a way that doesn't really seem to have been thought about why one would want to do it. So it would be pretty unusual in my experience of doing housing schemes of this sort to require, for example, a detailed daylight and sunlight assessment. Why on earth would we need to do that? There's no suggestion at all that the layout's going to give rise to implications on daylight and sunlight. And so unless there's a say for a specific policy reason why or whatever, obviously the council can advise, that's not an obligation that should be required through condition. And ditto, there's a few that fall into that basket, things like a thermal comfort assessment, a scheme of noise insulation. Why is that being asked for unless there's a specific policy requirement for it? Because, you know, I can't for the life of me understand why there'd be a noise issue here. F requires external facades and all of that to be confirmed. But as I've said, that'll already be confirmed by the nature of a reserve matters application. H requires details of site levels and all of that. I don't really understand why that's being asked for, but obviously scale and layout and all of that will already be required by the reserve matters application. If there's a particular reason for going further at H, then we need to sort of understand what it is. I requires internal layouts to be approved, which is not normally something that you'd need to do by way of a reserve matters application. That can only be done, in my view, if there is a particular policy, a local plan policy, which brings in the national space standards or whatever, and indicates that the council are going to refuse permission if they, whatever, if they're conflicted with or whatever it might be. But I don't understand there to be any policy reason put forward, in terms of the development plan to support what's at I. J, external lighting strategy, fine. Generally, the other ones, fine. Although with things like N, details of amenity spaces, well, I mean, that's covered by reserved matters, and if it's not covered by reserved matters, we shouldn't need to be putting it in. So there's a few of them that I think are simply duplicating what would be the case anyway with the reserved matters application. A few of them, and then there's some other ones which go further than a normal reserved matters application, but without any attempt at trying to justify them with reference to the council's policies, and so. There are other ones like, a LEMP or a whatever it is, a lighting strategy that I'm sure we've got no problem with those at all. That's absolutely fine. But I wanted to indicate that, I do think it goes a little bit, well, it certainly goes way beyond the norm that one would expect to see for a condition like this. And so I just wanted to draw it to your attention.
Well, I'll be looking at all these.
We won't die in a ditch about it.
You're not dying in a ditch on some of these, but I hear what you say. I mean, I'll be looking critically at all the conditions anyway against the tests set out in the government guidance over necessity and so forth. Any point to raise from the council on that?
Yes, I hear what you're saying, Mr. Simons. The detailed and sunlight assessment in particular, and also at criteria B, and then at criteria E, we asked for noise insulation, a scheme of noise insulation, sorry. There are going to be, or looks as though there's going to be flatted blocks, and there's going to be a 3-storey care home proposed on this site. So we would require daylight and sunlight assessment for those, and we would require a scheme of insulation for those, definitely. So whether they can be tightened up and wording in a way that they should be for those elements of the scheme. Also, the details of the existing and finished site levels, that is important. I mean, I've walked the site many a times, and as we did last week as well. I mean, it's a very uneven site, and we do get those site levels coming with any reserved matters should you wish to allow this development. I think that is important, so we can fully assess the actual site levels itself, because it's so uneven on that site due to undergrowth, etc. So, the extent. I think the external lighting strategy is quite important as well. I don't think you can disagree with that. Well,
no,
I don't think there's any dispute.
There's no dispute on that one at all. No, I think that's quite an important one, clearly.
Yeah. But yeah, there are reasons, and as I said previously, these are standard ones that we've had recommended and imposed on previous outline applications that we've recently had granted. So, but obviously it's in your hands, Inspector, so it's up to you.
Okay, well, I think these are your suggested conditions. I will be, if it comes to needing, should I allow the appeal and then move on to consider conditions, I will be looking at these afresh and assessing them against the tests. I think we could probably move on to the remaining conditions now, Miss Ellis.
Yeah, so moving on to condition 20, prior to occupation conditions, this is recommended by Essex County Council Highways. This relates to the access point of Potash Road. So as we know, it's going to be a vehicle access point, and then there's going to be a point access point for pedestrians and emergency vehicles only. We just require the access points to be carried out in accordance with the plans that were provided to us, and the actual vehicle access only onto Potash Road shall be constructed at right angles, and we expect a plan to be submitted to us to show the visibility displays of that access prior to first use. Then moving on to the compliance conditions, so we've got 20 to 24. This just relates to landscape replacement, requirement from the developers to provide us with implementation landscaping scheme. We've also got condition 22, which relates to super fast broadband on the site. 23 it relates to the accessibility and adaptability, which relates to building regulations. 10% of residential unit should be with approved document M42 category 2. So it talked about the accessibility and adaptability of dwellings. And then finally, 24 relates to the water efficiency. So all residential units shall comply with the water efficiency optional requirement in paragraph 2.8 and 2.12 of building regulations document G. So that's all the conditions that have
water efficiency is yes, well, that's the title of the condition. Okay, well, we've been covering conditions, I think, reasonably thoroughly. Any final points that Mr. Taylor wants to raise with me?
No, Chairman.
Thank you. I think we could probably have a short break now, unless you think the 106 can be dealt with within a few minutes.
I suspect probably, sir, it's, even though the drafting's agreed, it probably is more than a few minutes just to touch.
Let's have a little break now. So it's 10:25. I will resume at 10 minutes, I think. It's just a comfort break at 10:35. So I will reopen things then. So 10:35. I'm just checking my emails as I go. Mr. Taylor, you've raised your hand.
Yes. Well, in the welcome break, I was able to have a look at the schedule of conditions just sent to me.
Mm-hmm.
And looking at the wording, and under the CEMP biodiversity shall include the following. One of the bullet points, the wording used is location and timing of sensitive works to avoid harm to biodiversity features. I'm reassured by such wording, and I notice under ecological impact assessment 16, no development shall commence until further ecological surveys shall be undertaken at the site. That too I find reassuring. And under 17, provision of the full BNG calculations with detailed justifications for the choice of habitat types, distinctive and condition, connectivity, I see is specifically mentioned, and ecological functionality. Again, I find that wording reassuring. Thank you.
Thank you for that, those final words. So they provide some comfort. I'm not expecting you to change your opinion on the scheme as a whole, but I'm grateful that you had the opportunity to contribute to those conditions.
Thank you.
I think this will be your last opportunity to speak. So thank you for the contributions you've made, because we're hearing about the Section 106 agreement.
Yes.
Now, you may or may not have any comments. I think it's unlikely, but hear what's said. Following that, just to put Councillor Schrader on notice, we'll be inviting him to make a statement, and he will be speaking on concerns from interested parties as a whole. So that will no doubt pick up on what you've contributed. So thank you, Mr. Taylor. So I will now, perhaps you could just turn your camera off. I will invite Mr. Simmons and Miss Lilliot to introduce themselves. Or
I'll try not to do much of the talking, sir, if I can avoid it. I'll ask Miss Lilliot to introduce herself, and I see Miss Cook's turned her camera on as well. So
good, excellent. Let's proceed.
So yes, hello. I'm Joanna Lilliot from Holmes and Hill Solicitors. I've been acting for the applicant in the negotiation of this 106 agreement. I'm largely in your hands as to how you want to go through the agreement. I mean, I can go through it clause by clause, or I can use the SIL compliance statement and use that as a way of going through what's in the agreement. Over to you.
I think I don't want you to go through it with a fine-tooth comb, but no. I would welcome just a summary of what the parties have agreed. It's a bilateral agreement, is it not?
It is indeed. The agreement's been
explained to the inquiry that there'll be people listening on the live stream who'll be interested to know, without too much technical legal jargon, what it seeks to achieve, and I'll be very grateful if you could provide that.
Fine. The agreement's been executed by all of the landowning parties and the County Council, and the executed documents are with the council at the moment, but not completed, pending the result of this session. So the agreement itself covers a number of things. If I go through reasonably quickly, there is the usual clauses about payment of monitoring fees and binding land ownership. And there is what we would call a blue pen clause, which in effect means that if you are minded to grant permission and you consider that the obligations are Regulation 122 compliant, then the agreement secures all those obligations. If, however, you are minded to consider that they are not Regulation 122 compliant, then the agreement allows for a particular obligation that you consider is not compliant, not to be complied with. And that's standard provision in 106 agreements that are dealt with at appeal. So going through what the subject matter of what's in the agreement, there is a strategy for private sales, which the council's required. I should perhaps say that the council has provided us with this draft. We did not draft it. And I would say 90% of what was provided has been agreed by the applicant. And the other 10% is subject to the blue pen clause. I think that's the simplest way of saying it. There are strategies for private sales. There are financial contributions for employment and skills, which is £300 per dwelling. There is an ecological mitigation contribution, which this year is £156.76. However, along with a number of the contributions, the council has requested wording that allows them to use a figure that would be in place at the time of reserve matters. Now, I have to say I found this quite strange, because I think the agreement should crystallise at the time of the agreement, and then any figures are index linked up to, so that inflation is covered up to the time of payment. But we have agreed to that strategy. So there is £156.76 per dwelling for ecological mitigation. There is a health and wellbeing contribution of £170 per dwelling. I should point out that is not covered in the SIL compliance statement, and so we are not clear, other than what it says in the agreement, as to why that is required, given that there is also a National Health Service contribution of approximately £593 per dwelling. There is an open space, culture and sport contribution of £172 per dwelling. Again, it's either that figure or a figure that's in place at the time of reserve matters. And then there are two contributions payable to the council. One is called Highway Improvement and Pedestrian Access Contribution. It's £2,051 per dwelling at today's prices. And that is said to be for high quality improvements in the area. There is no justification for that in the SIL compliance statement. There is also what's called a sustainable transport contribution of £1,391 per dwelling. That is something that in the SIL compliance statement comes under contributions payable to the county council. The county council stated at a very early stage that they did not require that contribution, and we asked for it to be removed. The council have said that they do require it, and it is under contributions payable to them. But we are struggling to find the justification for it, particularly as there are improvements to local highways in the area being carried out by the appellant. And to a large extent, these two contributions both cover the same thing. And so, as I said at the beginning, they are in the agreement. If you find them to be compliant in the three heads of Regulation 122, then the appellant will be very happy to pay them. But we just wanted to raise that we are struggling to find the justification for both of them. There is also a financial contribution towards bus services, just on the transport note, and we would say that that contribution, it's 658,000. in some way duplicates what the council are asking for in those two contributions, the highway improvement and the sustainable transport. Just finishing off with highways, there is also a requirement for the appellant to provide in bus stop improvements and junction works at the Potash Road, Queen's Park Avenue roundabout. Those will all be covered by a Section 278 Highway Works Agreement at a later date. There is a provision for a travel plan to be provided and for residents to be provided with information packs as to sustainable transport generally. There are contributions towards education. The County Council has requested at this stage a contribution for secondary education and has quantified that. There is also a somewhat new, in my view, and I've been doing these agreements a long time, a provision for primary education, in that the County Council has not said they require a contribution at this stage, but they have asked for a review during the life of the development. And those clauses are some of the clauses that we have amended. in that we felt it was proper that review should be limited to a time period rather than what the county required, which was a general review during the life of the development, as any developer is entitled to know what they are going to be required to contribute. So there are provisions for that review to be carried out at a certain time in the life of the development. And if it's not carried out at that time, then the primary contribution is deemed not to be required. There is provisions for on-site open space, and that is largely to set out a specification for what is to be required on site and for it to be provided at certain times through the development, and for that open space to be passed to a management company for ongoing management into the future. There is provision for a plan to be provided and to be complied with for employment and skills, and that's largely to encourage the use of local employment during the life of the construction of the development, but I'm sure the council can comment further on that. And a quality review provision, which is for reserve matters to be submitted to a quality review panel if the council so wish that to happen. There is affordable housing. 31.3% of the dwellings on site are to be provided prior to 65% of the market occupancy. And there are schemes to be submitted to show the tenure of that affordable housing. And there is a care home on site, as you know, and that is to be age restricted to over 50 years of age. And I've covered the transport, so that's everything that's in the agreement. Very happy to take any questions or, yeah. Oh, I can't hear you.
You're on mute, Inspector.
Yeah.
Inspector, you're on mute, so we can't hear you at the moment. I don't know why.
Apologies for that. I was on mute, so you were listening to me mouthing away and not hearing anything. What I did say that you didn't hear was to thank Miss Lilliot for setting out that quite clearly. And what I think, before I move to Miss Cook and just ask the council to comment, if I could just ask you to summarise where should the blue pen be wielded, so to speak, where that might be, just so I'm perfectly clear. And now you're on mute.
It's now on mute. It's only one at a time, clearly.
Sorry, I'm back. I think you have a SIL compliance statement.
I do.
And we would say that in terms of what's in the SIL compliant or what's not in the SIL compliance statement, to a lesser extent, the health and well-being contribution, as it isn't covered by the SIL compliance statement. But largely, three areas: the highway improvements and pedestrian access contribution, the sustainable transport contribution, and to a lesser extent, the education review contribution, but purely on the basis is that our view is that it should be quantified. It should either be asked for now or not asked for. And I think on the two highway contributions, what we would say is that what we are providing and what the county council has asked for covers what has been requested under those two contributions. And the fact the county council is not asking for the sustainable transport contribution, and yet the agreement requires the council to pass it to them to be spent, is another reason why we would say it's not relevant. But again, in your hands on that. Yeah.
Thank you. Miss Cook, welcome. If you could provide me any sort of comments on what we've got an agreement. There's a few blue pen clause potential. You know, were it to come to that in the decision. Anything you'd like to comment on?
Yes, please. Good morning, Inspector.
Good morning.
Can I just respond to Ms. Lilliot's comment about highway sustainable transport? I'm not an expert on that area. Unfortunately, my colleague can't attend today. and you've captured it completely. Essex Highways have not requested those contributions, so we leave it on the table there for further discussion and agreement from the inspector. The education contribution, the secondary education contribution, I consider is justified in our calculations and is covered in the SIL statement. The review mechanism for the primary education, I understand, I appreciate your comments, Ms. Lydia, that it's either needed now or not at all. I, as this County Council, have had considerable discussions with my colleagues on this matter. We have agreed from our approach to introduce a review mechanism for this purpose. We consider it's necessary to be able to revisit the need for this contribution throughout the development, and I appreciate we have now agreed in the agreement, Section 106 agreement, that there is a time period for this review to take place, and there are stipulations as to whether the contribution can be payable or not, depending on how the outcome is, which also requires an action on your side to lay us with the information to allow us to carry out that review. We consider it's necessary. There are a number of speculative developments coming through in Basildon District. There is no local plan. We cannot continue to not request a contribution to cover the demand from these developments. The review will take place at that period, that time set out, so that we can review the need at that time, the demand from your development, any others that may have come in that time. And we have got that fallback where if at that time it's not required, you will not be required to pay it. We cannot justify a request for it at the moment. The data does not allow us to request it at the moment. But forgive me, it only takes 12 months to skew those figures. And if you came in with an application next year and asked for the consultation response, we may be able to have the evidence to support that request. So we request, Inspector, that you allow us to introduce the review mechanism to provide for any demand from this development.
For primary?
In this instance, it's primary education. It may in any future application, which we're not dealing with at this moment, but it's an opportunity for us to review this need and demand from the development at a particular stage throughout the development period. And we consider it's necessary to have this review mechanism within the Section 106 agreement.
Do you want to come back on that, Ms. Lilliot?
So I'm very happy with that. I have no further comments on what Ms. Cook said. That's fine.
Thank you.
Might just be worth saying one thing, sir, that obviously there's in the world of affordable housing review mechanisms, there's a very well established bank of policy and indeed case law that tells us how, those circumstances in which affordable review mechanisms will or won't be appropriate. And one of the things that, of course, we're looking for in that world is a specific development plan hook to enable an inspector or whatever to uphold a review mechanism. There's been lots of cases on the London plan and how that works, and here there isn't anything even close to a development plan policy basis to impose a review mechanism for something like this. And if this were the right approach, we'd do it all the time with everything. We'd say, well, we can't quantify this, that, or the other at the moment, but don't worry if you like, or not, don't worry, but we can defer the quantification of all this stuff to later down the line. And obviously it doesn't work. It because of that, it breaches Reg 122 very, very obviously and sort of directly. And there's no sort of clawback review mechanism basis in any policies. So that's the problem. Okay, any more from any party on the 106 agreement? Clearly it'll be for me, should I need to get to that. Ms. Hock, you've appeared and...
Hello, yes, sir. Sorry, could I make a couple of representations on behalf of the council in respect of the points that have been raised by Miss Lillian?
Yeah, I'd like to hear them now rather than never. So,
Miss Lillian has raised the matter of the highway improvement and pedestrian access contributions, and also the sustainable transport contribution. having reviewed both matters, the council does concede on the highway improvement and pedestrian access contribution heads of terms. However, in relation to the sustainable transport contribution, the council does believe that there is a document that supports the request for this contribution amount, and the amount is going to be used to fund the cycling and the bus and the walking routes in and around this development, and that is why we have requested this amount, and we believe it is supported. And we'll leave the health and wellbeing contribution to your view, sir.
Could I trouble you to just drop an email covering that?
Certainly, that's absolutely
just
fine.
to help me in case I haven't written down anything particularly clearly. Mr. Atkinson.
So it's perhaps a little late, but I'm sure you've appreciated that Ms. Hawke is from Basildon and Ms. Cook is from the County Council. If you're wondering why there are two solicitors appearing in this session.
Yes, well, actually, if I could ask the council perhaps to just put a total list of participants and their qualifications just to help me when I write my decision, because I have to put them anything. I wasn't quite au fait with that, so I'm actually glad you've qualified that.
Could I just say at that moment that I am not a solicitor? I think you've probably referred to me as one, but I'm a Principal Infrastructure Planning Officer. But yes, it will be handy to have that list of attendees.
So yeah, a list of attendees, and I think I do know who everyone is. And Miss Lilia, perhaps if I could have your qualifications via the appellant's team, that would be helpful, just to pop your names down. So Miss Hawke, on behalf of Basildon District Council, is just going to send me an email just confirming that they're conceding on the highway improvement requirement. So they wouldn't,
yes, sir, I will,
hypothetically object to a blue pencil clause in respect of that, but they are maintaining the sustainable transport requirement. And I think if you could just cover where that justification comes from,
yes,
as a reminder. I'll be going back to the SIL compliance statement. I'll be looking at the 106 in detail. At the moment, I'm running an inquiry, so anything that would help me would be more than welcome.
certainly,
Anything
sir,
further from any party that remains hanging, so to speak, in respect of the legal agreement?
Inspector, did you require any further information or comments from Essex County Council to support the request for the review mechanism within the agreement, or are you happy with my explanation?
I think a very brief email would be helpful, just summarising what you've said, if you wouldn't mind.
Okay, thank you.
I'm sure I'll copy it to the appellant so that they're in the picture. And it just means that I'm not writing anything that isn't correct. And Mr. Taylor, you've got your hand raised. Any?
Yes, Chairman. I hadn't actually heard any mention of mitigation at Junction 2, which is, of course, Potash Road to the Stock Road. Was that, as it were, implicit in the items you've just been discussing, or?
If the County Council can just remind me what the contribution, remind the inquiry what the contribution covers. It's not delivering that entire scheme, is it?
Is that a question for the County Council, did you say? Sorry.
Yes, it's
I missed the question, sorry.
It's the roundabout junction and the extra lane.
I am not qualified to answer any questions on highways, I'm sorry.
Yeah, that's...
Sarah, I might be able to help with that. I'm assuming that is the junction of Potash Road with Queen's Avenue.
One, yeah.
Yes, correct.
There is a requirement in the 106 agreement for the County Council to, the appellants to carry out improvements to that junction.
Yeah.
I do know that the appellant's highway consultant is listening in. If you'd like her to comment further on that, it's Victoria Rees. Would that help?
Would help me, arguably, the chairman.
Okay, Ms. Rees, welcome back.
At least I think.
Just
yes,
briefly.
I'm here. So that does relate to the junction improvements that were submitted as part of the application. So that is the improvement to the Potash Road entry and increasing the width of that. So that will be dealt with through a Section 278 agreement.
That's a highway agreement. Thank you.
Yes.
Okay, so I think that covers your point, Mr. Taylor, that is addressed.
Thank you very much, Chairman.
Thank you. Okay, now it's time for Councillor Schrader, hopefully, who's still in the meeting, to join us.
Yes, I'm here.
Hello, Councillor Schrader. Thank you for hanging on in there, so to speak. And I'm glad you recovered enough to join us, and disappointing that you weren't able to come to the inquiry last week. But I know that there is a lot of concern locally over this proposal. That's very evident to me. So it would be an opportunity for you just to make a statement on behalf of your constituents. So over to you, sir.
Well, a very good morning to you all. So may I start by thanking you for your indulgence in allowing me to address the inquiry at this late stage. I was terrifically ill last week, so I'm most grateful for the accommodation. You will be pleased to hear you very kindly allocated me half an hour, but I don't intend to take anywhere near half an hour. Much of what I wish to highlight has already been mentioned by others during the course of this hearing. Mr. Taylor in particular has been doing a sterling job. Indeed, I would also like to thank you for the considerable latitude you've afforded to the local residents who did attend last week, allowing them to play a full part in the proceedings. I know from having spoken to some of them that that was very greatly appreciated. I'll also try not to have a coughing fit halfway through if I can possibly help it. My name is Councillor Andrew Schrader. I've represented Billericay East since 2013, and I am a long-time resident of Billericay. I should add that I'm also the Cabinet Member for Housing at Basildon Council, as well as a standing member of the Planning Committee. But to be clear, I am here principally in my capacity as the local ward member to represent the views that have been communicated to me by my constituents. I suppose the elephant in the room with this particular appeal is that the appeal site was previously identified as a potential site allocation for development in the now withdrawn draft local plan known as Policy H16. I recognise that there is an evidence base underpinning that site allocation, but I need not remind the inquiry that the draft plan having been withdrawn and the council currently being engaged in the formulation of a new iteration of the next Basildon local plan, the site allocations in question, along with the evidence base and all the assumptions that underpinned those allocations, were never subjected to the full public examination by the planning inspectorate. So the soundness of those allocations has not been proven. It's possible that some of the Greenbelt housing allocations would have been deemed sound, while some may have been found unsound. I shall not speculate into which category H16 would have fallen, but my point is there is nothing to say it would definitely have been judged sound. I will state that from my point of view, as the local ward councillor, I previously expressed my doubts in relation to H16. I should just state for the record that a non-pecuniary conflict of interest, which could result in a perception of bias, led me to recuse myself from the local plan preparation process, so I didn't play any part in that. But once Basildon Council had voted in favour of publishing the draft local plan and sending it out to Regulation 19 consultation, I did write to the Planning Inspectorate on December 17th of 2018 to discharge my mind in relation to certain concerns I had, particularly in relation to H16. Many of my concerns and those of my constituents surrounded the narrowness of Potash Road and its ability to accommodate the additional traffic that would arise from a sizable new development at that locality, particularly the access points being proposed at the time. And with the nearby Stock Road roundabout, I was concerned proposals would cause considerable congestion at an already busy junction, exacerbated by the site's distance from Billericay High Street, the train station, and other services, all of which I felt would make additional vehicular traffic to and from any new development inevitable. I also raised concerns around the proximity of the site to the boundary between the boroughs of Basildon and Chelmsford, and my concern that a development here would encroach upon the precious metropolitan greenbelt that separates the town of Billericay from the neighbouring village of Stock and prevents the two settlements from coalescing. In my letter of December 2018, I also cited my concern that there would be considerable ecological damage resulting from a development at this site, particularly in relation to dormice, badgers, not to mention the loss of many mature trees, which would presumably have to be cleared to make way for any new development. Obviously, I hope it goes without saying that as a long-serving member of the planning committee, I've served on planning on and off for about six or so years, I think. I am always very cognizant that I must maintain an open mind in relation to each individual application that comes before the committee, and I judge each application on its particular planning merits. Nonetheless, knowing this particular site as I do, it'd be fair to say that the matters aforementioned were all issues of which I had an awareness and which I would be looking for any proposed development to demonstrably overcome, with a clear understanding of the proposed mitigations being advanced to support development. This particular proposal was submitted to the council in September of last year, but as you know, by the time it was submitted to the committee in October of this year, the application was already the subject of this appeal on grounds of non-determination, despite the fact that the officers had seemed to be dealing in good faith with the developer. I must accept, however reluctantly, that the local highways authority raised no objections. Using my local knowledge, I cannot say I'm able to rationalise that assessment by Essex Highways, but I have little choice but to accept it. I have been contacted by a number of constituents on Potash and nearby Mercer Road, concerned their road will become a rat run. But in the absence of any objection from Highways, this did not form part of the reasons for refusal put forward by the committee, and I do not advance it as one now, but I feel I would be failing in my duty as the local councillor if I did not simply state for the record that it remains a very serious point of concern to my constituents on Potash Road and the surrounding area. The committee nevertheless did resolve, in line with the professional officer's recommendation, that we would have refused planning consent, and I voted in favour of that recommendation. First and foremost, this is an inappropriate development in the Greenbelt. The land was not released and remains Greenbelt, enjoying clear protections within both the National Planning Policy Framework and our own local saved policy BAS GB1. This inappropriateness stems both from the general impact upon the openness of the Greenbelt and, as I previously outlined, the intensification of the existing large built-up area of Billericay and the extension of that urban area encroaching into the countryside that separates Billericay from Stock, contrary to the NPPF and the SAVE policies in the Basildon District local plan. Secondly, and this again goes back to the concerns I first expressed 5 years ago, the application provided insufficient information around ecology and biodiversity, meaning the application did not outline any mitigation or compensation for the loss of habitat, contrary to paragraphs 174D and 180D of the NPPF. In particular, as has already been mentioned this morning, the site has hazel dormice, which have already been referred to and which are priority species for conservation. Finally, there was the absence of the Section 106 agreement securing obligations and contributions towards affordable housing, education, public realm, etc., all of which are necessary to mitigate the impact of the proposed development. Just to quickly pick up on some other points, on the issue of 5-year land supply, it's generally accepted that the council does not have a 5-year housing land supply, though that's not for want of trying, sir. As I understand it, there are currently around 7,000 extant planning permissions across Basildon Borough. I think there is a degree of land banking taking place, but clearly our land supply position should get better, and we have the latest draft local plan due in Q3 of 2024, which should further increase supply. In any event, my own reading of the NPPF is that it seems perfectly clear that lack of supply should not remove greenbelt protections, and this ought to remain a clear reason for refusing development. Alterations to greenbelt boundaries should only be made through the democratic processes of the local plan preparation, and development should only be permitted in the greenbelt in very special circumstances when fully evidenced and justified. I should add that several constituents have questioned the deliverability of a scheme here. As I gather, there are some knotty land ownership issues, with the appellant apparently only controlling the landlocked western field. I don't possess sufficient intelligences to confirm that one way or the other, but if true, it does suggest that this could be yet another site that would take a significant amount of time to come forward, making it unlikely to contribute positively to the council's land supply issues in the immediate future. The affordable housing element of the scheme is clearly positive, and given the borough's admittedly poor housing delivery and shortfall in delivery of affordable housing, certainly it's not to be sniffed at. Nonetheless, revoked policy H16 required a housing development. This proposal includes a 50-bed care home, and it's not clear to me that the requirement for such a facility has been adequately demonstrated. Essex County Council, in their comments, referred to existing care home provision in Basildon being, quote, underused. The justification for releasing Greenbelt for this purpose is, I would submit, therefore dubious at best. Overall, sir, I would say that while the provision of affordable housing proposed here would be beneficial and welcome, the overriding adverse impacts of this proposed development, for which there is insufficient justification and inadequate mitigation, means that this proposal would be an inappropriate development, causing substantial harm to the openness of the Greenbelt, and would conflict with its expressed purpose of preventing urban sprawl and safeguarding the countryside from encroachment. The impact upon the hazel dormice population in Billericay will be particularly substantial. The benefits do not clearly outweigh the impacts, and with no very special circumstances having been evidenced to support an approval, cannot be said to outweigh the protections afforded to the Greenbelt in the NPPF. I very much hope, therefore, that you will dismiss this appeal and uphold the decision taken by my colleagues and I on the Planning Committee. Once again, on behalf of my constituents, I thank you for your consideration, and I take this opportunity to wish you, sir, and everybody else on the call a very Merry Christmas and a Happy New Year. Thank you for listening to me.
Thank you very much, Councillor Schrader. That was all very succinctly put, and I hope expresses the views, it summarises the views that I've read already. I think I'd like to take a short comfort break. It's now 11:15. Let's say 10 minutes again, so we can move things on and have lunch, because there's a lot still to hear. So I will adjourn now at 11:15 and resume again at 11:25 when Mr. Atkinson will be providing the closings on behalf of the council.
Mr. Inspector, please, can I just ask, am I excused from the hearing now? Can I?
Yes, thank you for your contributions.
Thank you very much indeed. Thank you.
Have a nice
Thank
Christmas.
you. And you too. Thanks very much.
Well, yeah. Okay. No. Yeah. Not now. Okay. Okay. Bloody hell.
Is Mr. Atkinson present? I'm revealing my ignorance here with Zoom.
So I am, but I can't see you. I can just see the back of your chair.
Let me see what I can do. You can't see me still?
No, I can hear some clicking. I can hear your voice clearly, but your picture is of the back of your empty chair, by the looks of it.
Right. I think my screen must have frozen because I'm now sitting in that chair.
Right.
Is there any advice? Could those?
Right, sir. If you just try and switch, if you switch your camera off and on again, sir, or try logging off and in again, that sometimes fixes it.
Yeah, I'm sure you're right. Okay, I will log off completely and then come back. So don't go anywhere.
Yeah.
Am I visible to participants?
Yes.
Yes, sir. Yeah.
Oh, good. Okay. Well, Mr. Taylor, I think I've given you enough time to contribute, I'm afraid. Could I ask you to turn your camera off?
Yes.
Please. And I am now inviting the council's barrister, Mr. Giles Atkinson, to deliver his closing statement. So I would like to focus entirely on him and that statement, which he has kindly emailed to me. So, Mr. Atkinson, over to you, sir.
Thank you, sir. It was said on opening, on behalf of the council, that what distinguished this case from others recently that have involved the proposed development of sites formally identified as allocations is the absence of demand for a care home and the failure to properly mitigate for loss of habitat for the dormouse population on site. These are the circumstances of this case, which ultimately tip the balance against permission. It is important, however, in focusing on those aspects that we do not forget the harm to the greenbelt that is agreed to be caused by the proposals. The agreement between the council and the appellant about harm is reflected in an agreement that substantial weight must be given to the harm to the greenbelt, following the guidance in the framework para 148. Inevitably, given the building over of an essentially open field, the harm to openness, particularly spatially, is profound, although the visual aspect of openness is more limited because of the existing enclosure of the site by vegetation. The witnesses conclude differently on the impact of the proposals on the greenbelt purposes in contention, those being A, sprawl, and C, encroachment, with Ms. Ellis expressing concern about the proposal jutting out from the built edge of Billericay, and also creating an enclave of open land between the proposal's western boundary and Stock Road. Mr. Hughes essentially finds less harm to purposes from the proposals as a result of the existing containment of the site. It is the harm to the greenbelt, together with the associated landscape and visual harm, insofar as separate, that count against the proposals being granted permission. Dormouse mitigation. although there is a disagreement ultimately about the adequacy of the proposed dormouse mitigation between the experts, Mr. Harvey and Mr. Saunders, there is nonetheless a measure of agreement about aspects of the survey that was undertaken and the guidance. It is agreed that Mr. Saunders' survey, although thorough, was not designed to and does not tell us how many dormice there are currently on the appeals site. The methodology employed tells us instead only of presence of dormouse. The survey was only of the appeals site, with no assessment made of any of the connected habitat beyond. It is agreed that the guidance is for there being no or minimal net loss of habitat. It is agreed that, in fact, the proposals in this case will result in loss of approximately half of the dormouse habitat. It is agreed that there is no published standard for determining quality of habitats. Your starting point in considering whether to accept Mr. Saunders' evidence or Mr. Harvey's is to bear in mind that Mr. Saunders does not have a full understanding of what the current dormouse population on the site currently is, because the survey does not tell us. Mr. Saunders has estimated the population based on his estimation of the suitability of the habitats on site. Ultimately, the suitability of the proposed mitigation is also based simply on Mr. Saunders' judgment about the size of the population that may be supported by the improved quality of the post-development habitat, notwithstanding that it will be half the size of the current habitat. The absence from the survey of any assessment beyond the appeal site means that it is not known how the dormouse population found to be present on site fits into the wider population. Only a partial picture is presented, and this may be one of the reasons why the population has been undervalued by Mr. Saunders. This means also that there is not a proper understanding of the value of the appeal site to the dormouse. It may be, as Mr. Harvey explained, that the appeal site is of particular importance at certain times of the year, but less so at others, coupled with the fact that all dormouse populations live at low density more or less regardless of the quality of the habitat, apart from the optimal habitat. The conclusion is that a poor quality habitat may nonetheless be of high significance to a local population. The mitigation proposed fails also to take proper account of the disruption inevitably caused to the dormouse population by the change from a rural or semi-rural environment to a much more urban one, with attendant lighting and predation risks, as well as the change of the layout of the existing food sources the population is familiar with, and the time taken for the proposed enhanced sources to come to fruition. Mr. Saunders is, of course, entitled and qualified to make judgments of the sort he has, but it is striking that his initial judgment of the population currently on site has been downgraded from a relatively high population, or as recently as November of this year in the mitigation technical note, a relatively high level of dormouse evidence, to relatively low numbers or low density in evidence for this inquiry. Given that Mr. Saunders authored all of the documents mentioned here, the downgrading / undervaluation is odd and not really explained in cross-examination, but serves mainly to undermine faith in all of the judgments which his case is founded on. The judgment of Mr. Saunders is important because ultimately it is being relied on to override very clear guidance that there should be no net loss, and so that is the original emphasis, not added by me, of dormouse habitat. But as agreed, there is in this case not just a net loss, but a loss of approximately half of the habitat. To observe that the guidance does not preclude the possibility of a lesser area being capable of supporting a larger dormouse population is to take the wrong message from what is abundantly clear. No net loss of habitat unless justified. The same guidance emphasizes the significance of quantity in the method statement, which seeks information about the quantum of habitat to be damaged or destroyed, set against that to be enhanced, restored, or created, all measured quantitatively, that is, in hectares or meters, with no reference at all to quality. Mr. Saunders' justification is based on a series of judgments, but they are undermined by his not knowing what the dormouse population of the site is to start with. His estimate of population derived from an assessment of the quality of habitat cannot be relied on because there is no consideration in the survey of neighbouring habitats. Given that the favourable conservation status, FCS, is founded on an understanding of what the population is and how a proposal will influence both that population and the size of the habitat to maintain it, that is a serious flaw in the methodology. The not unlikely to be licensed test from Prideaux is understood, although it is derived from that case which concerns an application for full permission, not outline. Nonetheless, as things stand, the information available to you, sir, is not enough for this test to be met. This appears to be accepted by the appellants, who emphasise repeatedly that any weakness in the mitigation can be adjusted at reserved matter stage. If this is correct, then the role of you, sir, in deciding whether the Prideaux test is met may be entirely bypassed. It would always be open to developers to promise to make good any deficiencies in mitigation at reserved matter stage, regardless of doubts in inspectors' minds at this stage. In this case, as Mr. Saunders agreed, the quantum of development, by which I mean 150 houses and 50-bed care home, would be fixed by grant of outline permission and unlikely to change reserved matters. That means that the quantum of habitat lost must also be fixed. So no amount of tinkering with the details at reserved matter stage is likely to be able to render a scheme unlikely to be licensed now, not unlikely to be licensed in due course. Ultimately, the undervaluation of the site's dormouse population and the dramatic reduction in post-development habitat means that Mr. Harvey's evidence should be preferred, and you, sir, on the basis of the evidence today, may not be confident that the scheme would pass the not unlikely to be licensed test. Future changes at reserved matter stage would not change this, given the fixed parameters of the quantum of development. Need for care home. Although there is clearly a different approach taken by the appellants and the council to the estimate of need for care homes, it cannot be said that the approach taken by the council is inconsistent with the advice in PPG. The relevant paragraph of the PPG, which is referred to in that SENA, also known as the SHMA 2022, says that projections of population of households by age group can also be used, before going on to state the future need for specialist accommodation of older people broken down by tenure and type, for example, sheltered housing and extra care, may, and that is my emphasis, not the original, need to be assessed and can be obtained from a number of online toolkits provided by the sector, for example, Shop At. This is very far from an exhortation that the Shop At tool or equivalent must be used. Mr. Tennant himself states that there is no standard method, and the fact the SENA does refer to Shop At and quotes resultant prevalent rates for forms of specialist housing other than care homes may be interpreted as a positive position that the authors of the SENA believe the method they have chosen to estimate need for care home spaces is actually preferable. Much is made of the inspector's decision at Ellesmere Road in Shrewsbury and how the council's approach there was found to be fundamentally flawed. The inspector in that case makes the point that there is no exact science for determining the level of need for older persons' housing or care needs, but it is not clear from the decision exactly what the council there did. They appear to have used a prevalence rate, but one which predicted a very low level of need for extra care market housing, what that appeal was about, of only 3.1 per thousand, in contrast to the council's estimate there of 30 per thousand. That the council's prevalence rate in Shropshire was approximately 10 times lower than the appellant's may have contributed to the inspector's damning finding that their approach was fundamentally flawed. In the present case, the difference between the prevalence rates preferred by the council and the appellant is less, 32 per thousand and 110 per thousand respectively. One of the sources of the appellant's rate describes the norms used in it as inevitably arbitrary, and the other source is necessarily high, and that's the Greater Cambridge study, necessarily high because it is derived from the 100 local authorities with the highest level of care beds in the country. In contrast, the occupancy-based prevalence rates for the southeast of England are at 53 per thousand, closer to the councils. In light of these considerations, the council's reliance on the methodology for assessing need for care homes in the SENA 2022, and in particular, its prevalence rate of 32 per thousand, working out as a need for 19 per annum for the period 2020 to 2040, appears to be perfectly sound and presents no reason for you so not to rely on it too. Ms. Richardson's updated survey, showing that 60 spaces are currently available, may reasonably be interpreted as being indicative of there being no unmet need currently. The starting point for considering supply is to observe, with reference to Mr. Tennant's proof, table 24, that the council has in broad terms been granting permission for care home spaces in good number recently. This is the background to the focus of the difference between the parties on supply, how to deal with the net loss of rooms following the redevelopment of Gilgrove and Chaplin Lodge, as meaning the pipeline supply is 45 on the appellant's position, or 156, the council's position, a difference of 111. The total number of spaces lost within these redevelopments is 111, the great majority at Gilgrove. We know Gilgrove had only 47% occupancy at the last CQC inspection, meaning that 90 rooms were then vacant at that facility. These 90 rooms account for the bulk of the difference of 111 between the parties. It appears that Gilgrove was uniquely underoccupied before it closed, suggesting it was not, in effect, really meeting demand even before it closed, and it is therefore reasonable to treat the redevelopment of Gilgrove exceptionally as neutral. On this basis, the housing land supply figure for care homes is, as calculated by Ms. Richardson, over 8 years. The reality is that in contrast to its market housing position, the council is maintaining a good supply of care home spaces to meet its identified need, even without considering the potential for an additional 111 spaces from the 3 applications shown on Mr. Tennant's table 24, currently awaiting a decision. Balance and conclusions. The weight given to the factors pointing away from grant of permission, the harm to the greenbelt and landscape and visual harm, are agreed as set out above. Added to these factors must be the failure of the proposals to mitigate adequately for the loss of dormouse habitat, which attracts substantial weight against the grant of permission. On the plus side, it is agreed that the maximum weight should be given to the provision of both market and affordable housing as part of the proposed scheme, given the council's poor delivery of both in recent years. Whether this is called substantial or very substantial is not of enormous consequence. They are essentially the same. For the reasons set out here, the position in respect of the care homes is different, however, because the evidence shows the council is delivering more than enough to meet the identified need. Limited weight should be given to the provision of 50 care bed spaces, but the effect of this on housing provision overall is to reduce the positive weight by a notch, however articulated. It is agreed now that significant weight in favour should be given to the biodiversity net gain, so long as this is ensured with a condition. The economic benefits are presented in a slightly faux scientific way, but ultimately it is submitted that Ms. Ellis's assessment giving these moderate weight is the correct one, given that the bulk of the economic activity is relocated from elsewhere within the housing market area. On the eve of the inquiry, the decision at Dunton Road was issued. That appears to have been a straightforward poor housing numbers versus policy protection of greenbelt balancing exercise, which fell in favour of the development in that case. This case is different, and what makes it different is the absence of need for the care home element of the proposals and the failure to mitigate adequately for the loss of dormouse habitat. These factors tip the balance away from grant of permission, so it cannot be said that the harm to the greenbelt and other harm is clearly outweighed by other considerations. The consequence of this is that, in what has always been a finely balanced case, the correct decision is to dismiss the appeal and refuse planning permission.
Thank you very much, Mr. Atkinson. Just looking at the clock, I wondered if Mr. Simons is fit and able to.
Don't know about fit, sir. Maybe not fit, but just about able, I think. If you've got, I hope I've been sent through to your case officer, sir. So
well, let me just get, like I did with Mr. Atkinson, that on my screen.
You received it, sir. It was only sent maybe 5 minutes ago or so.
I may not have quite got it yet.
It was sent to same place as
yeah, it all goes to the same place. It's just
it went to Kerr Brown. Was that the right case officer?
Absolutely the correct place.
Okay.
What time was it given?
It was maybe 4 minutes ago. So
yeah,
not long, to be fair.
What I probably need to do is just pause you there, and I can just ask them to.
Of course, I will hang tight.
This is where my multitasking skills get sorely.
We'll press the pause button so you let us know.
I've just sent an email. The trouble with the way we operate is that I rely on emails to me, and so I think what I will do, if you wouldn't mind, is just adjourn for 10 minutes.
Of course, sir. Yeah.
Because it would be. Oh, hang on. Hang on. This looks
I heard
promising.
the ping.
Good. That's excellent. I've now got it.
Marvelous.
In front of you with a nice photograph at the front. Is that correct?
The one, sir.
Appellant's closing submissions. I will now mute myself and leave it to you. And
thank you very much indeed, sir.
Thank you, Mr.
Now, for all of the documents before you, the issues in the appeal are simple, and indeed most of the important points are now agreed. The issues which remain in dispute are actually very narrow, and I'll just add in, we got that impression from Mr. Atkinson's closings. In particular, the council agrees with us that if you find that the scheme's benefits clearly outweigh its harms, you should allow the appeal. The council's case at the start of this inquiry was that this case was a fine balance, and for reasons that we'll get back to, that in the end isn't a defensible position, not anymore. The adopted local plan is from another era. The basis on which its countryside and greenbelt boundaries were drawn up are completely and substantively out of date. The council's best case projection is that a new plan's at least 4 years away. The shortfalls in market and affordable housing in Basildon are acute, they are stark, they are chronic. The future is extremely bleak, not our words, the words of various inspectors who have been examining the position in Basildon in the last year or so. The council's latest housing delivery test score was 41%, which is the 7th worst in England. The council's failed, we agree, to meet important government objectives. Marcellus accepts that there's no effective plan-led system in Basildon within the meaning of paragraph 15 of the NPPF. She also agreed that the objective of at paragraph 8b of the framework to ensure that a sufficient number and range of homes can be provided to meet the needs of present and future generations is being failed big time. For the council actually to start addressing its housing needs now, The challenge cannot be met through the plan-led system. Ms Ellis agrees that if housing needs are to be met, the use of greenbelt boundaries is inevitable, as was found to be the case in the extensive evidence base supporting the recently withdrawn local plan. That demonstrated that housing needs in this area simply cannot be met on urban land alone, not even close. And Ms Ellis agrees there's no evidence from the council in the public domain to suggest otherwise. We agree that the provision of market and affordable housing should be afforded top-tier weight. Ms Ellis called it substantial. Mr Maxwell called it very substantial. We also agree that the scheme has a range of other benefits: provision of a care home, economic benefits, BNG, sustainability, provision of publicly accessible open space, public transport improvements. Against these benefits, we agree there'll be at least some harm to the green belt. However, as Mr Hughes has explained, the council's own evidence base shows this is one of the lowest performing parcels of greenbelt in the district, and consequently our scheme will not compromise the greenbelt's wider strategic function. We agree that an appropriate scheme to mitigate the development's impacts on dormice can come forward along with reserve matters, which would be likely to be consented by Natural England. Come back to that more. We agree there are no other technical constraints to delivery in relation to highways, heritage, air quality, drainage, flooding, noise, or indeed anything. And of course, we agree that, that until recently, the council itself was promoting the allocation of this site for residential development, and that the evidence base supporting the now withdrawn local plan weighs, quote, very heavily in favour, to use the language of the Dunton Road inspector and also the Kennels Lane inspector, very heavily in favour of granting permission at this appeal. As matters stand at the close of the inquiry, we're dancing on the head of a pin. The only 2 points that the council said at the outset tipped the overall balance against the grant of permission in this case, such that the test at 148, the framework, was not, so the council thought, passed in favour, were: number one, the alleged absence of demand for care beds, reducing the weight attributable to this benefit. So the council said, although, remember, not actually giving rise to any harm. And secondly, a debate about mitigation for dormice. That's it. For the reasons we give below, the council's case on the first issue, care bed spaces, is fundamentally flawed, and its case on the second issue, dormice, has fallen away through concessions made by Mr Harvey in cross-examination. In the end, if the council ever wants to start meeting its shortfall, not of tens, not of hundreds, but of thousands of homes, then this is exactly the sort of scheme it's going to have to start approving. Close our case under a number of headings, sir, that I won't read out, so I'll read them out when I get to each one. The first is the plan-led system has failed in Basildon. This part of Essex, sir, has been let down by the planning system. Years go by, decades pass, national policies come, as they will do later today, and they go. But through it all, this council's managed to keep its head buried firmly in the sand. There's no strategic review of the green belt in Basildon for decades. New plan-making exercises have been tried. They have failed. For too long, Basildon has been frozen in aspic. National policy expects the review and amendment of greenbelt boundaries to happen through the local plan process at least every 5 years so that needs are properly accommodated. But here, the greenbelt boundaries around Basildon have been fixed for over 30 years. The Basildon local plan was adopted in 1998 with a plan period running to 2001. The greenbelt and settlement boundaries in the adopted plan are even older. They were fixed by the Billericay local plan, adopted in 1989, 34 years ago, well over 2 decades before the first framework. Those boundaries were carried forward into the Basildon local plan, which itself was only designed to accommodate housing needs up to 2001, over 20 years ago. So it comes as no surprise, then, that Ms Ellis accepts that the most important policies for determining this appeal, including those which prescribe the greenbelt boundaries, are not only deemed out of date under national policy, which of course they are, they're substantively out of date too. The greenbelt boundaries were drawn to accommodate the needs of a different generation in a totally different local, regional and national policy context to the present day. This has a bearing on how much weight they can be given. Ms Ellis accepted all of that stuff in cross-examination. Those out-of-date boundaries have resulted in 63% of the district being within the greenbelt, essentially everything outside the urban boundaries, as you can see on this now familiar plan. No wonder then that the new plan for Basildon, submitted to the Secretary of State in 2019, proposed that swathes of Greenbelt land be released. Housing needs can't be met in Basildon without the release of land from the Greenbelt. That was, as Ms Ellis accepted, inevitable. She confirmed that there's no subsequent evidence in the public domain to suggest anything else. And just to be clear, sir, with an eye on what's happening, maybe even as I'm reading this out to you, that will remain the case. It'll remain the case even if the NPPF were adopted broadly in the form of the consultation draft, i.e. it would remain the case that albeit authorities like Basildon are not required to review their Greenbelt boundaries through local plans to meet housing needs, if authorities like Basildon do decide to try to meet their housing needs, which has been their position so far, it is inevitable, and it has been, it will remain inevitable, that homes will be required on land which is currently within the Green Belt. Of course, the last time the council undertook a review of its Greenbelt boundaries, that exercise led to this site being proposed for release from the Greenbelt and allocation for housing through the 2019 plan as site H16, as you know. The council's own evidence base supporting the allocations demonstrated over the course of many years that this site is appropriate for significant residential development, a point to which I'll return. In February 22, the council's members voted to withdraw their plan, taking us right back to square one. What about the future? Well, we're now told the council doesn't expect to adopt a new local plan until, at the earliest, 2027, the end of 2027. That's 4 years from now, 30 years after the last local plan was adopted. But the council recognises that there are several factors which may impact on the ability of it to keep to the timetable for the production of the new local plan, including changes to national policy, guidance or legislation, and changing political priorities, all of which is happening today. And so Ms Ellis accepted the council's projection for adoption by the end of 2027 is not set in stone, far from it. We simply have no idea if or when a new local plan will be adopted. It could be many, many more years from now. We live in hope. The plan-led system has failed in Basildon. The consequences of the council's failure to plan are serious, agreed both by Ms Ellis and indeed by several appeal inspectors in the last year or so. Families unable to afford somewhere to live, thousands on the housing register, unsustainable solutions with people being forced to find a home further away from where they work, shop and socialise. The position is described properly by those other inspectors as acute, extremely bleak, stark, and extremely serious. We know that there is no prospect of a plan-led solution to the problem in the short to medium term. Housing needs must instead be addressed then through the DM process, through planning applications, indeed through appeals, just like this one. Next heading says the scheme's benefits will be very substantial, starting so with affordable housing. The council's own evidence in Ms Richardson's proof tells a dreadful story. She acknowledges an identified need of 521 affordable homes a year. She recognises that over the last 5 years, delivery has fallen significantly below this need, with 223 affordable homes being delivered in total over that period. So on the council's own case, this is their case, over 90% of the need for affordable housing in this area is going unmet, resulting in a backlog of not hundreds but thousands of affordable homes already. She rightly agreed that this represents a significant unmet need, which of course is right. Mr Tennant's figures paint an even bleaker picture. By taking account, as he does, the loss of affordable housing stock through right to buy, he demonstrates that for two of the more recent monitoring years, the net additions were in fact negative, not positive. For the 6-year period from 2016 to 22, Mr Tennant's evidence reveals net additions of 24 affordable homes, 24 in 6 years against a total need of almost 1,800. So in other words, when you account for right to buy, the council's actually only met 1.3% of its affordable housing needs over that period. None of that was challenged by Ms Richardson. And even those figures, bleak as they are, based on the assumption that the 521 a year figure taken from the, I'll call it the SHMAR, is accurate. Mr. Tennant challenges that assumption in his evidence, updating several of the Schmal's inputs to account for more recent data than was available when that document was put together. Ms. Richardson didn't directly rebut any of that stuff from Mr. Tennant in writing or really during her evidence in chief either. She did say that she was unclear as to the origin of 3 of his inputs and she challenged a 4th. Now, Mr. Tennant explained each of those challenged inputs, and we've set out in writing, sir, from over the page from A down to D, what he said about each of them. Not going to read them out. It was questions of detail, but you've got them there for your reference in respect of the challenged columns, if you like. So on to paragraph 24. In short, Mr. Tennant's evidence, which appears to be uncontroverted, subject to the explanations and slight revisions above, is that the true need figures over 1,000 affordable homes a year. It's double the Schmar figure of 521. And if you accept that, and as I say, it's not really controverted, then the crisis of affordable housing is far more serious than even the council's own stark data suggests, with all, of course, the very real consequences which flow from that. As for supply going forwards, the council's not giving you any evidence on that. We have. And indeed, Mr. Tennant estimates delivery of 76 affordable homes every year going forwards, resulting in a shortfall over the next 5 years of over 4,800 affordable homes. That evidence wasn't rebutted, it wasn't challenged. Indeed, Ms. Richardson confirms that the council's position is that future supply is going to fall significantly short, and it's not challenged the extent of the shortfall set out in Mr. Tennant's evidence. She agreed the vast majority of affordable housing needs will remain unmet, and the backlog will continue to accrue to the tune of thousands of homes, at least until a new local plan is in place, which we know is years away, at least 4 years away. Now, it's easy to get lost in all these numbers, a lot of numbers. But as Mr. Tennant's evidence explains, the effect of all of this is a very serious shortfall in affordable homes, and that will have serious social and economic impacts on the residents of Basildon. As Inspector Woodward remarked in the Maitland Lodge appeal last year at Billericay, the persistent, extremely low affordable housing delivery in the past years has contributed towards real-world harm. He said that each of the thousands of affordable homes which he found should have been built but hasn't been, represent a missed opportunity to help alleviate the housing concerns of individuals and families. This in turn represents he said, significant conflict with the economic and social overarching objectives in the framework. In light of what he called a critical situation, he afforded very substantial weight to the proposed affordable homes, all of them, not just those which were over and above the policy requirements. Similarly, in Kennel Lane, Inspector Dillon considered that scheme's delivery of 72 affordable homes would contribute significantly to addressing the existing and predicted very serious housing shortfalls in the next 5 years. And she gave that factor very considerable weight in the balance. And yet again, in the recent Dunton Road decision, Inspector Masters afforded very significant weight to the delivery of affordable housing, given the continuously poor position in terms of affordable housing delivery across the borough. Our scheme would provide 47 affordable homes, contribute towards addressing the dire historic delivery of affordable housing in this district. Mr. Maxwell was right to afford that very substantial weight in the balance, and Ms. Ellis agreed it should be given top tier weight. Market housing, sir. The position on market housing is similar to affordable. Much of the very bleak positions common ground between the parties. The council's got on its case, it's got a 1.85-year supply of land. Its delivery test action plan shows under delivery for 6 of the last 8 years, which it describes as persistent under delivery, which has resulted in a significant shortfall of housing in Basildon. This has implications, it says, for the local housing market and has contributed towards house price increases and reducing affordability in the borough. Its latest housing delivery test score, as I've said, is 41%. So it's achieved 41% of its expected housing delivery across the relevant 3-year period. It makes it the 7th worst performing authority in the country. Scoring 75% or less on the HDT counts as substantial underperformance under the meaning of the framework, and that's footnote 8. Basildon's underperformance is very substantial. The upshot of that is a historic shortfall in the region of 1,600 homes. Looking forwards, most recent data shows a shortfall of 3,936 homes over the next 5 years. That's not going to get any better materially until a new plan is in place, and we all agree about that, and that is at least 4 years away from now. The appeal proposals will deliver up to 150 homes, with an additional 32 freed up by those moving out of existing accommodation into the proposed care home. Ms Ellis, in her proof, gives this substantial weight in favour of the proposals. She confirmed during her evidence she was not adverse to affording it very substantial weight in line with Mr Maxwell, and that obviously is the same thing as has been done elsewhere. The care home. Turning then to the first of the two issues which the council began the inquiry, and indeed has just closed the inquiry by relying on to tip the balance, so it says, against granting planning permission, the alleged absence of a demand for care beds. Despite the significance of this issue for the council's case, so we're told, the difference between us boils down to two simple points, one on need and the other on supply, and that's it. The first one is the council right to calculate its target need figure by reference to a prevalence rate derived from the 2011 census? That's the question. And note, sir, if the council are not right, if they're not right about that, then that's the end of it. That disposes of this issue in our favour. And point B, which I'll come to in a minute, becomes irrelevant, because if the council's wrong about the 2011 census data, then it has no evidence to suggest its supply comes anywhere close to meeting its true need for care beds. That's agreed. So that's the first issue. The second is, assuming then that question A is resolved in favour of the council against Mr Tennant, is the council thereafter correct to discount net losses of care bed spaces in calculating its future supply? We say no to both of those questions. Taking them in turn, first the point about the prevalence rates. The council's case on need is pinned to this idea that the number of care home bed spaces it needs is 19 every year. That figure comes from the SHMA, but the SHMA tells us it was relying to produce that figure on the 2011 census data, which showed that at that stage 3.2% of residents in Basildon over 65 lived in communal establishments. Now, what the SHMA does is to assume that the same proportion of those aged 65 and over will continue to require a care bed space into the future. So what it's doing, it assumes that, 12 years on from the 2011 census, the proportion of people aged 65 and over remains and will remain the same. That's its assumption. And Ms Richardson adopts this assumption in her evidence. She relies on the SHMA. She offers no material to support the robustness of its assessment. She just says, I agree with it. Mr Tennant's evidence is that this assumption is totally inappropriate. And he explains how it risks, more than a risk, it perpetuates a historic undersupply of this specialist form of accommodation into the future. This risk is one that's been recognised in this sector for years. In the More Choice, Greater Voice document in 2008, it was acknowledged that it's unlikely that the current pattern of provision will have developed in response to assessed need, but rather in response to short-term demand and provider perceptions of what will be popular and fundable. That's the problem if you do it the way the council have done it. Instead, Mr Tennant relies on the Shop Act tool, which is produced by Housing Lin. This, together with the 2017 Greater Cambridge study, supports a prevalence rate of around 110 in 1,000 who could be expected to live in residential care and nursing home accommodation. Use of the Shop Act tools, not just our idea, it's supported by the government in the PPG, which I won't read out. It's also supported, the prevalence rate's also supported by this more recent Cambridge study, which was based on a robust assumption that areas within the top third or so of local planning authorities, so the top 100, are more likely to have achieved a better, not perfect, but better balance between demand and supply. It was also, this approach, supported by a number of inspectors, but including Inspector Nurser in the Ellesmere Road appeal decision that you've got in the core documents. Now, in that case, what happened was that the council was relying on a prevalence rate that was derived from a SHMA, which presupposed that, this is the inspector's language, at a fixed point in time, the level of older persons housing and nursing care provision was appropriate to provide the optimum choice of tenure care and needs for Shropshire, in that case, Shropshire's elderly population. That was there. This is here. Same thing. She considered that that approach was fundamentally flawed, and she preferred the appellant's approach, which was based on a Housing Lin document. So it's the same sort of debate before you. Ms Richardson agreed in cross-examination that the approach taken by the council in that case followed the exact same logic as the council in that case. Mr. Atkinson's closings suggest that there's some kind of distinction from our case because the prevalence rate in that case was lower than it is here. With respect, totally irrelevant. The flaw is in the logic. Very clear. If you assume that a particular prevalence rate which existed at a fixed point in time should remain the rate that we should plan for, it's an absurdity. It is, as the Shrewsbury inspector described it, a fundamentally flawed approach. And the council has adopted the same fundamental flaw here of supposing, without any evidence at all, that the level of specialist housing in 2011 was appropriate to provide optimum choice. Well, if Mr. Tennant's approach is right, and it is consistent, of course, with the planning practice guidance, it's also consistent with Inspector Nurser. The current need figure for care bed spaces is 970, and it goes up to 1,845 by 2043. And Ms. Richardson agrees that if that's right, council's got no evidence as to what the need actually is, or whether the council thinks it's got an adequate supply. She also agrees there's currently no plan-led approach to meeting any of this need and no strategy for delivering sites for care homes outside of the green belt. She confirmed she's not aware of any other suitable sites that could come forward to meet the demand. So, turning to the second of the points that you need to decide on, if you're against us on the need point, that's the supply side of the equation. On this, the council relies on two consents, which add up to 150 bed spaces. Pips, Hill Road, and Fairview. And those figures are all agreed. But the council ignores two other recent consents because those recent consents resulted in a loss of care bed spaces, Gilgrove and Chaplin Lodge. And we've set out details of those in Mr. Tennant's proof. He explains out a Gilgrove, which involved the demolition of a 169-bed care home and its replacement with a 66-bed, resulted in a net loss, and it's the same kind of thing at Chaplin Lodge. Accounting for these net losses, Mr. Tennant concludes the council's got a supply of 45 bed spaces over the next 5 years. The difference between this figure and the council's 156 turns entirely on whether the net loss is accounted or not. Miss Richardson's attempted justification for ignoring these net losses is that the, quote, lost bed spaces were of poor quality and have been replaced by better quality accommodation. But the council's presented no evidence, literally no evidence at all, these bed spaces that were lost were somehow incapable of occupation, nor does it account for under-occupation or poor quality of existing accommodation in calculating its existing supply. Indeed, Miss Richardson ultimately accepted in cross-examination there was no basis for, quote, forgetting, that's my word that she agreed to, about the net losses. However you resolve the issues above, so we agree that the appeal scheme's provision of a 50-bed care home is a benefit. The only issue between us is the weight that you give to that. If you agree with Mr. Tennant's approach to either the need figure against which supply should be calculated or the supply, then there's a clear need for this form of accommodation. If you agree with him on those issues, then the need's even more significant with a future supply of only 2.37 years. As to the weight attributable to the benefit, the parties agree that the need to provide specialist accommodation for older people is recognised by the PPG as being critical. And Ms. Ellis agreed this indicated a serious high priority objective of central government. Ms. Ellis also agreed that her attribution of only limited weight to this benefit stemmed from her reliance on Ms. Richardson's evidence on need and supply. She confirmed that if you were to agree to Mr. Tennant's evidence and find there's a significant need for care beds in this district, she'd be giving it considerable weight. She further agreed that a range of benefits flow from this kind of specialist accommodation, freeing up family housing, beneficial impact on the health and well-being of older people. Mr. Maxwell, relying on Mr. Tennant's evidence, gives it very substantial weight, given that it will address a clear and significant need. A range of other benefits flow from the scheme, and we differ to a degree on how much weight should be given to them. On economic benefits, Mr. Maxwell's proof appends a report from Lambert Smith Hampton, which summarised in his evidence. Scheme will result in 122 construction jobs during the build period and 64 permanent jobs once complete. In addition, it'll lead to £28.5 million increase in spending in the local economy over a 10-year period and savings of £1.5 million to the local authority. Ms. Ellis improperly reduced the weight she attributed to these important benefits on the sole basis that it was unclear to her whether the jobs would be taken up by people who lived in the scheme, which obviously is completely irrelevant. The framework tells us that significant weight should be placed on the need to support economic growth, ... And in light of that, Mr. Maxwell's attribution of significant weight is clearly to be preferred. BNG. Mr. Saunders' original proof referred to the BNG report carried out by Ecology Solutions. His rebuttal updated the figures to deal with an issue on additionality raised by Mr. Harvey, resulted in a reduced BNG figure of 16.96% for habitat units. Mr. Harvey confirmed that this recalculation satisfied his concerns, such that there's no longer any dispute between the parties on BNG. Ms. Ellis had in her proof of evidence reduced the weight attributable to BNG, which the scheme will provide to limited, based on Mr. Harvey's additionality concerns, but of course those concerns have now fallen away, and she eventually, during cross-examination, agreed to adjust her weighting to moderate in light of the updated position, but she wouldn't go as far as significant, so she said, because she had a concern as to whether the proposed habitats improvements could be delivered on site. She could not explain why this was relevant, but she did agree that if a condition was agreed by the parties that guaranteed BNG will be delivered by the scheme on or off site, she'd adjust her weighting to significant. And of course, we've done that now, and you've seen that today. Overall, then, in light of the fact that there's no current national or local policy guidance or legislation setting out a quantitative requirement for BNG, the scheme will provide considerably in excess of anything that might be required. This in turn chimes with a very important government objective, and Mr. Maxwell's clearly correct to attribute it significant positive weight. Also, publicly accessible open space, which is, as we've explained, the site's obviously privately owned at the moment, secured and inaccessible to the general public. Ms. Ellis accepted that the proposed scheme will provide areas of open space that are open to the public, not just occupiers of the scheme. These areas include woodland, children's play areas, green spaces, the retained pond, and spaces for informal recreation within a natural setting. Ms. Ellis gives only limited weight to that. She considers people won't travel to the site to use it, despite agreeing this is a sustainably located site, providing a genuine choice of travel modes, and we give it moderate weight. Public transport improvements, you've heard a little bit about that today. So the scheme will secure financial contributions towards public transport enhancements, including the enhancement of existing bus stops in the vicinity of the site and improved bus services along the Potash Road corridor. Ms. Ellis and Mr. Maxwell agree this is a benefit that will benefit existing residents in the locality in addition to occupiers of the scheme, and they end up giving it moderate weight. Of course, overall, sir, your ultimate assessment, the weight to be given to these various things, isn't a mathematical exercise. It's important to take a step back and to look collectively at all of the benefits that will be delivered. And we say that when you do that, the overall picture is clear. The scheme's collective benefits are considerable. They should be given very substantial weight in the overall planning balance. Turning next, sir, to landscape impacts. There's no objection to the appeal proposals by the council on landscape grounds. Indeed, we agree on a number of important issues, reference to the landscape statement of common ground. The appeal site is not within or in the setting of any statutorily or locally designated landscapes and is not a valued landscape within the meaning of the framework. Mature trees on the appeal site boundaries enclose and contain the appeal site and offer considerable screening of views into and out of the site. These will be retained, obviously, along the northern, western and eastern boundaries, as you've heard about. Impacts on the landscape would be restricted to the site itself. There's no current public access to the appeal site and no public rights of way in its immediate vicinity. The site, as you will have seen, is well contained from publicly accessible views and has a high level of visual enclosure. As a result, the visual effects of the proposals will be localised and limited to those perceived by a select group of private receptor groups, as landscape architects call people. A further support for this is drawn from the council's own outline landscape appraisal of potential strategic development sites from 2017. This document, which is undertaken by an independent landscape consultancy for the council, should be said, this document confirms that the site is well enclosed, that it forms a visually contained edge to Billericay's urban area. The whole site is considered to be of lower sensitivity due to its association with the existing urban edge of Billericay, gentle topography and enclosure from public view. Albeit the council's closings today refer to landscape and visual harm, we've agreed, as I've said already, there's no reason for refusal on either of those issues, and that's reflected in the statement of common ground. As Mr. Hughes explained during the roundtable session, the scheme is a careful and sensitive response to the site's character and its on-site features and constraints, and he concludes there'll be some localised landscape effects to be weighed in the balance, and Mr. Maxwell ends up giving them moderate weight. Next, sir, the scheme's impacts on the wider greenbelt will be very limited. And again, happily, there's much agreement between us when it comes to greenbelt matters in this appeal. We agree that the appeal site only makes any contribution to 2 of the 5 greenbelt purposes in the framework, A and C, no harm to any of the others. Impacts on the greenbelt will be limited to the site itself, with dense vegetation on the boundaries of the site restricting encroachment within the wider landscape. There'll be no impact on the spatial openness of the greenbelt beyond the appeal site. There'll be no impact on the wider appreciation of visual openness in longer distance views. This level of agreement is unsurprising in circumstances where the council's own evidence base supports the release of the site as part of a wider parcel of land from the greenbelt, as best reflected in the 2018 Greenbelt topic paper, which identifies that the site's partially enclosed by development, and tree belts to the northern, eastern and western boundaries provide a defined boundary. It concludes that so long as the latter are retained and enhanced, harm to the greenbelt associated with the development of the site would be minimised. And importantly, it also concludes that the role of the remaining greenbelt would remain unchanged. The appeal scheme includes the measures identified within the topic paper as necessary to reduce the impact of development on the purposes of the greenbelt. We're agreed that the evidence base in support of the plan, including this topic paper produced by the council, weighs very heavily in favour of the appeal. And this all leads Mr. Hughes to reach the following conclusions on greenbelt impacts, which he summarised in the round table. First, on purpose A, the site is very well contained within the wider greenbelt, contributes only partially to this purpose. It's adjacent to the settlement edge of Billericay, partially enclosed to the west, and has an existing relationship with urban sprawl, for example, the sporadic development like Foxfield House. He notes the proposal won't result in any ribbon development and will be strongly contained by the existing boundary features. This all results in limited impacts to this purpose at a site level. As to purpose C, the site's located in the urban fringe and is already influenced by the existing urban edge. Again, the strong sense of containment within what Mr. Hughes describes as a robust framework of tree belts and other mature vegetation on the boundary of the site will restrict encroachment within the wider landscape. Those limited people who do have a view into the site from their homes or from the adjacent equine centre will experience moderate and minor adverse effects. And again, Mr. Hughes concludes the impacts on this purpose will be limited and only arise at a site level. Openness. In spatial terms, Mr. Hughes notes that 55% of the site will be retained as undeveloped, as shown on the land use plan, which sets the parameters to be fixed. Harms to visual openness will be limited due to the agreed visual enclosure of the site. Those limited people who do have a view into the site from their homes or nearby equine centres will experience a moderate adverse effect. Once again, limited, localised, no effects on the openness of the wider greenbelt. As we know, Ms. Ellis agreed, the council needs land, which is currently in the greenbelt, in order to meet the enormous and urgent housing needs we've already described. It does not have a plan-led solution to manage those releases, which means that impacts on the greenbelt, one way or another, through development management decisions like this one, isn't a choice. It's inevitable. The real issue comes down to whether schemes can come forward which do not unacceptably impact on the greenbelt's wider integrity. And this is such a scheme on a site assessed by the council itself when carrying out a review of all of its possible greenbelt sites, being a lower performer against greenbelt purposes and is suitable for development with no impact on wider greenbelt function. Overall, Mr. Hughes was clearly right to assess the overall greenbelt impacts of the scheme as limited and localised. Of course, though, we must give them substantial weight in the overall balance, as we'll come back to that in a moment. Penultimately, sir, the development can deliver appropriate mitigation for hazel dormice. This then, sir, is the second of the 2 issues that the council said when the inquiry opened, and indeed when they've just closed their case. But this is the second of its 2 issues which it thinks tips the balance against granting permission: the impacts of the proposals on the local dormice population. All other ecology issues have been agreed, and I've set out what some of those are. At 56, this part of the council's case stands or falls with whether the scheme is capable of providing adequate mitigation. And when I say capable, I mean to Natural England's satisfaction for the site's hazel dormouse population in due course. And by due course, what I mean is when detailed proposals are worked up at the reserve matters stage. What is the legal test? In assessing the adequacy of the mitigations, it's important to understand what the test is that you're actually being asked to apply. And on that, we agree that the hazel dormouse is a European protected species. Deliberate disturbance of it is an offence. But under Regulation 55 of the Habitat Regs, licenses can be granted to enable certain activities to be undertaken, which means that the offence doesn't apply, so long as you're doing it within the terms of the licence. The licensing body is Natural England. 3 tests are applied by Natural England in thinking about whether a licence should be granted. The first one about preserving public health and public safety or for other imperative reasons of public interest. Second relates to satisfactory alternatives. And the third relates to, and this is obviously critical, whether the action will be detrimental to the maintenance of the population of the species concerned at what is called a favourable conservation status in their natural range. The first 2 tests are principally planning considerations and will be met, essentially, if you grant consent for this scheme. The third test is an ecological consideration, the touchstone for which is maintaining the favourable conservation status of the relevant population. And by Regulation 9 of the Habitats Regs, authorities, including you, sir, must have regard to the requirements of the regs when you exercise your functions. But what all of that actually means was considered by the High Court in the Prideaux case, that you've got the whole judgment obviously in the core documents, but the court summarised the test to be applied by planning decision makers in this way. If a proposed development is found acceptable when judged on its planning merits, permission should normally be granted, unless, in the authority's view, the development would be unlikely to be licensed under derogation powers. So unlikely to be licensed by Natural England, that's the test. That's the key question for you, sir. Is a licence unlikely to be granted by Natural England for the proposed development in light of the mitigation measures proposed, having regard to, of course, the all-important test of maintaining the favourable conservation status of the species? The council suggests in its closings, without ever quite saying it, that this test is restricted to cases where full rather than outline permission is sought. And that is with respect, if that's what it's saying, that's nonsense. The law in this area is perfectly clear. The test applies, regardless of whether you're considering a full or an outline planning application. It's next suggested that this test would mean you could always, quote, bypass, to use Mr. Atkinson's term, the test by promising to make good any deficiencies at the reserve matters stage. Again, with respect, that's nonsense. For an outline planning application, where there remains so much detail still to be approved, the whole point of the legal regime in this area is that only showstoppers, which is to say situations which are not likely to be capable of mitigation at all, are stopped now. That's explained in quite a lot of detail in Morge and in Prideaux. Not gone into all of that, but you've got the judgments in the core document. It recognises the more limited role of planning authorities and the inspectorate in considering issues of this sort versus, of course, the specialist regulator, Natural England. Nothing's bypassed. If the mitigation in the end is inadequate, the scheme won't be built. But there's no need to countenance that possibility at this inquiry, because the main parties are, in fact, agreed that a scheme is not unlikely, sorry, double negative, to be licensed in due course. We agree on that. And turning to the application of the test in this case, surveys carried out by us in 2020 and 21 confirm the presence of hazel dormice on this site. This survey effort is now agreed by the council to have been in excess of what we had to do under the guidance for this sort of survey. Nonetheless, we get a whole page of the council's closings dedicated to criticising the survey effort, which, to be fair, takes us nowhere, because as we've seen this morning, further surveys will be required, both by condition and to satisfy Natural England in due course. There's no requirement in any of the relevant guidance to conduct surveys off-site, and that exercise would be unnecessary here, because as we've explained, we have assumed that the dormice on this site are indeed part of a wider population, and our mitigations designed accordingly to facilitate them. We also agree that the scheme risks leading to the disturbance of dormice population present on the site, so we're going to need a licence. We agree that it'll be for Natural England to determine whether to give us one, and it's no role of this inquiry to supervise them in doing that. Your role, sir, we agree, is to apply the test in Prideaux, which is to consider whether the licences are unlikely to be granted by Natural England. And in doing so, of course, you have to have regard to the fact that you've got before you an outline scheme, and that the determination of a detailed mitigation strategy will inevitably be something that comes along with reserve matters. The mitigation strategy as currently submitted relies on the retention of habitats on the site identified as being of higher value to dormice and the enhancement of other retained habitats to elevate their carrying capacity for dormice. In other words, the core of the strategy is to increase the quantum of high suitability habitat on the site to offset the removal of habitats of lower quality and lower value. Strategy is illustrated in our various plans, and it shows that existing boundary habitat is going to be retained and enhanced to ensure continued connectivity between on-site and off-site habitats. It shows dormouse nest boxes being installed throughout the site to enhance nesting opportunities. It shows dug-in log piles created throughout the site to enhance dormouse hibernation opportunities, and it shows all habitats being subject to woodland management measures, including the removal of non-native species and bolstering with native species like hazel, where appropriate, to enhance the carrying capacity for dormice. Mr. Harvey's biggest concern about our mitigation strategy, he said, is that it would result in a net loss of dormouse habitat on the site. But he agreed in cross-examination that quality of habitat, quality has a bearing on carrying capacity for dormice. Therefore, you can have a net loss of habitat while maintaining the favourable conservation status of the protected species. And that means, of course, that a net loss of habitat does not mean that a licence will be refused. Ultimately, when it comes to the key question of whether the proposed mitigation will maintain the favourable conservation status of the dormouse population, Mr. Harvey was unable to say whether it would or whether it wouldn't. But he did agree in the end that a licensable scheme is possible here on this site as part of this scheme. We agree, particularly noting that as above, over half the site is going to be retained as undeveloped land through the parameters plan. So there's ample scope for further retention and enhancement of habitats. If Natural England require it, we will see. With respect, the idea in the council's closings today that, quote, no amount of tinkering, as Mr. Atkinson describes it, in the reserve matter stage can improve the habitat's position for dormice is nonsense. And the council's own witness confirmed as much by agreeing that there can indeed be here a scheme which achieves a licence. Contrary to what Mr. Atkinson is now telling you in his closings, his own witness confirmed in cross-examination there's more than adequate scope to adapt the mitigation scheme if it's required in order to obtain a licence in this case. And that's enough. That's enough to satisfy the Prideaux case in relation to what is an outline planning application. It cannot be said, indeed it's not being said by the council's own witness, that Natural England's unlikely to grant a licence in due course. End of story. So, if you agree with Mr. Harvey and indeed Mr. Saunders that a licensable scheme is possible on this site, you can safely grant planning permission, and that's it. And on that basis, the council's case has fallen away on what it was telling us anyway was a critical point of dispute. In any event, you've got Mr. Saunders' clear evidence, obviously a very experienced ecologist who's held several dormice licenses under his own name, and who, remember, unlike Mr. Harvey, has actually visited the site more than once. You've got his evidence that the proposed mitigation strategy would be acceptable and it would enable the favourable conservation status of the dormouse population on this site to be maintained and a licence to be secured. And so, finally, sir, in the end, the position is straightforward. We agree with the council that if the proposals pass the test at 148 of the framework, they also comply with the statutory development plan when read as a whole, aged though that statutory development plan is. Which means, sir, for you, the question is simple. Do this scheme's benefits clearly outweigh its harms? If they do, the parties agree that you should allow the appeal and grant planning permission. In answering that question, it's important to remember that the council opened its case and has now closed it on the basis that the scales were finely balanced and only two factors tipped them against granting planning permission for this scheme: the need for care accommodation, and noting, of course, that even on the council's case, it doesn't actually lead to any planning harm, and the inadequacy of proposed dormice mitigation, albeit the council's witness confirmed that a dormice licence can be granted in due course by Natural England. We also note that Mr. Atkinson's closings, just like in Miss Ellis's proof, it's not actually said the scheme's harms outweigh its benefits, and that's because they don't. In any event, if you prefer the evidence of Mr. Tennant and Mr. Saunders on these two issues, the council's case falls away, and in the end, Miss Ellis accepts that in that world, you should be granting planning permission. And we've obviously already set out the reasons why you should. On the benefit side of the scale, the failure of the plan-led system in Basildon has had and will continue to have real consequences for real people. As we've said, most of all, and for many years, the council's not come anywhere remotely close to meeting its needs for market and affordable housing. Shortfalls aren't marginal, they're abysmal, chronic and severe, to the tune of thousands of homes, with all of the terrible social, economic and environmental consequences that failing to plan brings. Families unable to afford somewhere to live, thousands on the housing register waiting not weeks or months, but years to find a home, unsustainable solutions with people being forced to find a home further away from where they work, shop and socialise, and the inability of essential workers to live locally. In this district, the plan-led system has failed, and our case is simple. There's no short or medium-term prospect of it being fixed. The real issue before you, sir, is whether the many people in need now should have to wait at least 4 years until a new plan is adopted by the council, and indeed units start springing out of the ground under that new plan, or whether urgent problems require more urgent solutions. And against that pretty bleak background, this scheme presents a remarkable opportunity, because it's a visually enclosed site outside of any landscape designations or their settings, in a highly sustainable location, which has been assessed by the council as being suitable for release from the greenbelt to accommodate development of the scale currently proposed. Aside from ecology, there are no technical objections from the council to the scheme coming forward. There are, for example, no objections from any of the expert consultees on drainage, highways, Environment Agency, Natural England, Historic England, anything. As I've explained, the scheme will generate a number of important benefits: BNG, jobs, making the natural beauty of the site accessible to the public, and improvements to the local bus service. But even more importantly, it would deliver desperately needed market and affordable homes. And we agree with the council these benefits are top tier benefits in your planning balance, whether you call it substantial or very substantial. And on top of all of that, the scheme will deliver a 50-bed care home, which would, on Mr. Tennant's evidence, contribute to a very significant need for this form of specialist older persons accommodation. It would, on either party's case, contribute to a national need, which the government has itself identified as being critical. Taking it all together, sir, in the end, we're asking you to give those benefits very substantial weight. And the case, again, against what Mr. Atkinson was telling you, the case is analogous. And I know I was there. The case is analogous to the very recently approved Dunton Road decision, which was not, as the council tells you in its closings, just a, quote, housing numbers versus greenbelt kind of case. There was more going on there. There was, in particular, unlike here, a vociferous debate about the relative locational sustainability of that site, which obviously in the end was determined in the appellant's favour. But if anything here, of course, the case for approval is stronger here than it was there, because the range of benefits includes a wider suite of residential accommodation, i.e. the care home. It was not a benefit on offer at Dunton Road, which the council agrees here is a benefit which weighs in favour of granting permission. And I suppose I should add, sir, locational sustainability, of course, very much agreed in this case, not at all agreed in the Dunton Road case. So if anything, stronger here. Our case is straightforward. The benefits before you are profound. The imperative to bring them forward is compelling, and they clearly outweigh what will in the end be only a localised impact to this appeal site and its immediate surroundings. For those reasons, the balance at 148 of the framework, not, I should say, one of the paragraphs which is up for amendment later on today, 148 of the framework tilts decisively in favour of granting permission, and we will ask you to, sir, allow the appeal. Thank you very much.
Thank you very much, Mr. Simons, for that closing statement and for keeping within your time you set. That's all very helpful, which takes us up to time almost to close. Just to reiterate the fact that we are expecting a revision to government policy today. I've not checked the news. Obviously, I've been listening to the closings, but there will be an opportunity for further comment on that, and I'll be informed by our corporate steer on what we do, but we await that with interest, obviously. So all that remains for me to do is to thank the advocates and both the teams, thank also all the participants, thank the council for hosting the face-to-face event and this Zoom meeting. So I think that concludes everything. So I will close the inquiry.
Thank you very much, sir.
Thank you, sir.
Very happy Christmas, obviously.
Yeah.
Thank you.